My lord, I'm sorry, my lord. In furtherance to my affidavit, my lord, which I filed day before yesterday, my lord, I filed another affidavit, my lord, giving more details, my lord, which is completely spreading a venom, my lord. My lord, that is, my lord, he states in his statements, my lord, like while talking to the press, Kashmir.
May I make a request, my lord, as it is we are short of time. Let us finish. Please.
No,
Now,
where is-
let me finish.
Mr. Judge,
Yes.
Mr.
No,
Solicitor,
with a sense of
let's see what the
response-
solicitor has to say, and we'll come back to you in a moment because we want to get on with the merits now.
That's
No,
right.
correct, Manoj. That's all,
Give us a
Manoj,
moment
our
to read.
intention is. Lord,
Yes.
with a sense of responsibility, I received the affidavit yesterday. I went through in the night. I would request your lordships to see 3 statements, and I leave it to your lordship's conscience. Lord, please come to page 6. And I'm saying this with a
I'm
responsibility.
sure Mr. Sibbal
As a-
will place the affidavit before us in the morning.
It's not there.
As a citizen of India, my lord, forget,
All right, one
we are all citizens
All
of
right,
India.
just a second. Mr. Sibbal, yes, please, let's have a look at the affidavit. and-
Lord, can I show, my lord, only
Malad,
3
this is only-
pages, few lines.
Again, it's just, Malad, I'm sorry to say, this is all being televised.
So you file an affidavit.
It's all being televised.
My lord, I'm making a
Let's-
statement, I'm not doing it.
let's-
Sir,
All right.
you are making
Mr.
these
Judge,
statements.
Mr. Judge,
Really is.
Mr. Judge, one second.
I'm sorry.
Solicitor is in charge on this side. We'll
Okay,
hear.
allow me, my lord, before Mr. Sibbal responds, allow me to.
Of course, I'm only telling Mr. Judge that you are in charge on your side, so let
Lord,
one
can you
person.
see, my lord, page 6.
All right.
I'll not read everything,
And then
page
we'll
6.
immediately come back to Mr. Sibbal.
Page 6, my lord.
Don't read it, just let's. see
Para
what-
2, I'll not read, my lord. Para 2. My lord, the first thing which was yesterday, my lord, highlighted was in the assembly. Para 2. This is in Kupwara in a public rally. My learned friend has an objection of it being televised. He said this in a public rally. Then, please see 4, 18th March 2019, my lord, before the presidential proclamation. Then 5. My lord, 5 may look innocuous, but I'll show, my lord, how it is not. My lord, 5, but whenever terrorist attacks takes place, the terrorist is killed, the civilian is casualty, and the security forces are killed. The sympathy is only for terrorists and the civilians. Please come to page 8 directly. Lord, only as per report in Greater Kashmir and thereafter the later part. Then kindly come to, my lord, page 11, my lords, which is more serious, my lord, in my personal view, my lord, subject to your lordships, my lord, accepting that. This is 19th March 2015. Please read, my lord, 1. Then please read 3. 3 is, my lord, very, very serious. It's not just Zindabad. It is again 15th of September 2019. Then 4.
Yes, we've seen it.
My lord, 4 middle.
We have,
My lord, 4 at the bottom.
we've seen it, we've seen it.
India is referred to as if it's a foreign country.
All right, yes. Yeah, yes, Mr. Sibbal.
My lord, therefore, I was
Will you
insisting
please allow
yesterday
me now, sir?
that his affidavit must say that I withdraw these statements. I do not support terrorism. I do not support any separatist activity, and no citizen in this country can logically
We must have a
any
uniform
objection
affidavit for
in
every
filing.
citizen to file this, Malad.
Can I just
In
say
this
something,
court.
Manoj? That point 3 at page 6, they say pushing a separatist agenda. Filing a 370 petition in this court is pushing a separatist
I'm
agenda.
sorry.
I have a very strong objection to the government of India taking this.
I am
stand here.
sorry.
All of us are pushing a separatist agenda by being.
Please.
One second.
No, I'll clarify.
One second.
Malad, I can-
Mr. Solicitor, please wait for a second. Mr. Shankarayan, I think this is unfortunate. Nobody can say that because a petition under 32 has been filed, up to this point, nobody has said that the filing of a petition constitutes separatist agenda.
I have said,
We have
saying that?
why this date is mentioned
One
even
second.
after filing, yes.
the access, one second, access to our court for ventilating grievances of citizens within the framework of the Constitution is a constitutional right in itself. anyone who accesses justice under Article 32 cannot be turned out on the ground that you are following this agenda or that agenda. On merits, which way any individual petition goes is for the court to separate the grain from the chaff.
May I clarify?
But I don't think,
have-
we have not, Mr.
the
Shankaranarayan,
intervener,
we have not heard the government.
saying this about us.
We have not
Only
heard
a
either.
minute, Mr.
One second,
Shankaranarayan.
Mr. Solicitor, 1 second. We'll put a lid on this now. Otherwise, this will go on endlessly.
Only give me.
1 second. We have not heard either the Attorney General of India, who is leading arguments for the Union of India, the Solicitor General, who has shouldered a large part of the burden, say that these petitions should be dismissed on the ground that they are separatist agenda. They have argued the matter on merits. It has been argued on constitutional terms. We have indicated that that's how we are going to resolve this issue. And I don't think that's been the main plank of either the solicitor, the attorney, or anybody who else who followed.
That's all I'm.
Sometimes when individuals as interveners come before the court, we also as judges understand that
They are
there is
petitioners. They are the lead petitioners.
there's an anguish which was
Solicitor
expressed,
is not the interviewer.
and that anguish which many of the interveners have expressed, we as judges know how to deal with that.
Give me a minute more. Give me a minute more. The date for 18th March is mentioned that petition is filed to show that even subsequent to the filing of the petition in May to 2018, etc., my lord, this continued.
Mr. Solicitor, you have made,
Filing of a petition
Mr.
is
Solicitor,
not as
you have made your point. You have made your point, Mr. Solicitor. Mr.
Yes.
Sibal.
Well, I hope that sentiment applies to us also because we have not made any submission other than on the law and the constitution. Just as the other side has done it, Mullah, at least we have not made any submission outside of that, Mullah. And we want to carry on this debate, Mullah, through the constitution, not through processes of this nature. Anyway, Mullah. Now, Mullah, yesterday your lordships asked me a question about merger, how many mergers have taken place. Kindly come to volume 4.
Malord, I leave it to the court, Malord. I
Mr.
understand.
Judge, Mr. Judge, please don't interrupt. There's a limit to it.
There is a boundary.
Yes.
Mullah, it's volume 4.
Just 1 second, Mr. Sibal.
That's another 20 minutes gone.
Mr. Sibal, is your client, has he filed an affidavit pursuant to what?
He is going to file, he is going to reach by 12 o'clock.
Yes, now on merits, Mr.
Yes.
Sibal.
So, Mullah, volume documents, volume 4, PDF 303.
Volume 4.
Yes, PDF 303, Mullah. This is in the white paper, Mullah.
303?
303. Mullah, this has taken 20 minutes. Yesterday, half an hour. The lordships had given us from Monday, Mullah, onwards, morning, Mullah. How do we finish?
This is the white paper that is.
White paper. Now, let's kindly see appendix, statement showing area and population of states which have merged with the provinces.
I'm sorry, which page are you referring?
Page 303, PDF 303.
PDF 303 in volume number 3.
In volume number 4, document volume 4. It's very important, Mullah. So this is, as I told your lordships, all the states who joined the provinces. And then they were merged, provinces which merged. So they first joined the provinces and the provinces merged. And you have 21 such mergers. And the dates of the agreements are on the left side. 1148, 1148, 1248. This is after January 20, before January 26, 1950. This is important. This didn't happen with as far as J&K is concerned. Now, this is now one part. Now kindly come to the next table. That is statement showing area and population of states constituting central administered areas, which were the chief commissioners' provinces. Now you see here, there's no question of any merger. No question of any merger. It was directly administered. And but through merger agreements.
Now these, just for a factual clarification, these centrally administered areas, what was their status under the Government of India Act? Were they were treated as chief commissioners' provinces, and they become centrally administered areas
Yeah,
after.
correct. Now come to the third. These were princely states, Malas, which actually went to the unions. These are princely states, Malas, many of them. Kindly see, Malas. Manipur, Tripura, Bilaspur, Kutch, Haroch, Chamba, Mandi. These are all Raja of Mandi. These are all princely states that merged into the chief commissioners' provinces, which are termed as chief commissioners, directly administered.
Then the third statement is those which constituted unions.
That's right.
So
Now
they formed a union of more than one of the.
Correct. Now this is important, Mullahs. Kindly see how the merger agreements here, only 5. Now you'll see, Mullahs, item 1, 22 units, as I told your lordships yesterday, in Saurashtra. Then, Mullahs, Jodhpur, Jaipur. This was called originally Rajputana, which included all these. Then you have 15648, Madhya Bharat. Your lordship sees that? Madhya Bharat. Then 2848 Patiala, East Punjab, Union, Travan, and then Travancore, Cochin. This is 552. Total 275, grand total 552. So you have therefore the chief commissioners' provinces. You had the province, princes merging into the provinces, and you had these 5 states. All through merger agreements. No exception, except Jammu Kashmir. Because that was not conceived in terms of 370 itself. Now kindly come to 373, Madas. This is also important. PDF 373. 3. Now what in these 5 provinces called the Union of States, what were the kind of notifications issued, Malas? What are the kind of proclamations issued? Your lordships will find at 373 onwards.
So this 552 was an addition of 216 plus 61 plus 275.
Correct.
Yes.
Correct, Malas. So now if your lordship comes to PDF 373. Now, you see that Raj Pramukh of Union of Patiala, East Punjab states, Saurashtra, Travancore, Rajasthan, Madhya Bharat, rulers of Hyderabad, Mysore, Jammu Kashmir are published. This is the proclamation. What does the proclamation say? Last paragraph, I now hereby declare. Your Lordship has that? My Lords have that? It says, I hereby declare that the Constitution of India shortly to be adopted by the Constituent Assembly shall be the Constitution for Patiala, East Punjab, as well as other parts of India, and shall be enforced as such. Come to the next one, Mullahs. Each of them, Mullahs, had the same proclamation. Each of them. And all that happened prior to 1950. Except Jammu and Kashmir. And you'll find that at 379, Mullahs.
Sybil,
And see if you...
Mr. Sybil, do you think it would have been a unilateral action or it was?
Sorry, I can't
action-
hear you.
It was an action on its own, or it was something which was the government of India at that time ensured that it happened? Obviously, the government
Mullahs,
of India, government of India
Mullahs,
ensured that it
there
happened.
was no question on its own, Mullahs. It would never happen like that. Some of them couldn't exist independently.
So, we have understood your argument on that. Can we move on?
Now, Mullahs, look at PDF 379, because all those proclamations are different from the proclamation Kwe Jammu Kashmir, which is Mullahs 25th November 1950, before Mullahs the 26th January 1949.
The proclamations is the firman of the Nizam as well. The Nizam you find at page 377,
Yeah, but the language
23rd
is,
of November
but the language is
1949.
different.
This was certainly not voluntary.
Of course not. Of course not, Mullahs. I agree. This is what I responded to my Lord. But Mullahs, the language is different from Jammu and Kashmir.
So keeping you probably in J&K, keeping at that time the political environment, it was something different. Was something different.
That's all that I'm saying, Manoj.
That's
My
the argument we have understood that
Yes,
argument.
and therefore it was incorporated in these terms in the Constitution, which was not done by anybody else, which only shows to you that merger was never contemplated except in terms of 370. All the others became Mullahs through these proclamations, part of these states, and then became part of B states. Mullahs. All these states became part of B states. Jammu Kashmir Mullahs were not. It was the only state excluded from Part B states.
But equally, the proclamation which Yuvraj executed, which you find at page 379,
Yes.
which we have seen earlier,
Yeah.
says that the entire relationship between Jammu and Kashmir and the Union of India will now be governed by the Constitution of India.
Correct.
And all previous understandings
Are gone.
are all superseded.
Absolutely. And see what the language is. The Constitution of India shortly to be adopted shall be insofar as it applicable to the state of Jammu and Kashmir, govern the constitutional relationship. So you go back to that. That is 1 and 370 only, Malak. Nothing more than that. I just wanted to show your Lordships, Malak, because your Lordships put me this question. I think it was a very significant Malak's query. And they all followed a uniform pattern of integration, other than Jammu Kashmir. And Malak, the white paper also says that the integration of states did not follow a uniform pattern in all cases. You will find that, Malak, at page PDF 46.
Because you have to deal with them differently. All the
Naturally.
I have understood that argument. Today, the issue is not this. Today, the issue is whether 370 was really a temporary thing and whether in terms of 370, it could have.
I'm giving the historical background to show the difference and why he did not merge, because in the meantime, many things had happened, including the matter going to the UN. This all happened prior to this, Malak. Therefore, the question of merger didn't arise. That's the point, Malak.
That has all been argued in your opening arguments.
No, I'm only giving the background to 370, Malak. I'm not arguing it. My Lord put it to me. I'm just giving the background, nothing more. I'm not arguing. I've argued 370, Malak. I'm not arguing, Malak.
Historical background also you are given in your opening argument.
No, not the merger, because my lord put me the merger agreement. There's a difference between merger agreements in all other states at that time, that is the 552 states, and except for Jammu and Kashmir. That's all, brother. And they have argued merger. I did not argue. Anyway, be that as it may, Malaz. Malaz, if just one other thing, Malaz. Since we are at this, Malaz, your lordships put to me yesterday, and then I'll come back to Malaz, the 355. Your lordships put to me that, look, there is a silence here in the Constitution. Malaz, I just want to answer that. And I'll Malaz, read what I have to say on this, Malaz, so that it's on the record. My first statement is integration was completed when the Constituent Assembly of Jammu and Kashmir completed its task and the Constitution of Jammu and Kashmir was adopted on 26th of January 1957. The governing structure comprising the Constitution of India and the Constitution of Jammu Kashmir complement each other, and through the bridge of Article 370. The scheme operated without conflict for 70 years. This very scheme. There was never a conflict. 2, through this complementary structure, the vast majority of provisions of the Constitution of India are applicable to Jammu and Kashmir in one way or the other. This was the integration meant. Nothing further needs to be integrated. Indian constitutionalism is not bound by a single scheme of legislative relations or any homogeneous understanding of the concept of integration. 3, Article 370, sub-article 3 is not silent. What is my answer to that? It is not silent as to the consequences reflecting the relationship between Jammu and Kashmir and India after the Constitution of Jammu and Kashmir was framed and the Constituent Assembly completed its constitutional task. This is further buttressed by the fact that in 1954, by CO 48, a proviso was added to 368(2). That can't mean that the 370 was silent on the consequences. If it was silent, 368(2) proviso would never have been added. Ensure that Article 370 could not be amended, even through the exercise of constituent power, and that by virtue of CO 48, the boundaries of the state of Jammu Kashmir could also not be altered, as long as 370 was in place. The Article 368 does not apply to 370 is clear from the fact that 370 starts with a non-obstante clause. So it was not silent as to the consequences. Next, there were no silences left to fill except the silence of the people of Jammu and Kashmir, who were never consulted and taken into confidence when issuing CO 272 and 273. That's the only silence that prevailed. Bilateralism is at the heart of the mechanism provided by Article 370, in terms of which laws applicable in the Union of India through the Constitution of India as applicable to Jammu and Kashmir are to be applied. It is this bilateral process which allows for a process of integration that is constitutionally envisaged in Article 370 of the Constitution, and any adjustment of the relations between Jammu and Kashmir and the Union must follow this bilateral process. And last of all, even with respect to 368 of the Constitution, the process of exercise of constituent power resulting in amendment of the Constitution is also given effect through a bilateral process. Bilateralism is at the heart of the said process because you have to consult at least get agreements of at least half the members of the states. That too is a bilateral process. Nothing can happen outside there can't be a unilateral act of an executive, not even parliament. Consider this, Malaz, what we're talking about, a unilateral act of the president acting on the aid and advice of Council of Ministers, not parliament. So, Malaz, with respect, I say there is no silence. So that was, Malaz, just our submission, Malaz, on that issue. And then kindly have a look quickly at the Constitution of India for a minute, Malaz. Kindly, Malaz, just look at this. Yes. Now, if you see, Malaz, I'm not going to read the language. Just want to ask your lordships to notice 3 things. 1, there are entire Article 370 has 2 colons. The rest are all semicolons. And the two columns reside where, Malas? They reside in D. There's a colon after D. And there is a colon after 3. 370 sub-article 3.
Colon after D.
D, Malas 37 1D. And colon after 370 sub-article 3. So you cannot exercise that power independent because it's integrated. The process is integrated, and it's only a process that we are talking about. We're not talking about powers here. 370 is only a process of integration. And Miller's Constitution Bench and Manohar mentions that. And we are dealing with the process adopted by the government of India consistent with this process of integration. We're not talking about anything else, Millers. There is no unilateral notification issued by the government of India, by the President on the aid and advice of the Council of Ministers that's before you. There is no unilateral declaration. And I'll assume for a moment, Millers, there is a silence. How will your Lordship, Millers, integrate that silence into 272 and 273? Because 272 and 273 deals with 370 sub-article 3 as it stands. You will still have to say whether 273, 272, 273 is consistent with the unilateral notification to be issued by the President, which is not there and which is not before you. It's not possible to match the two. It's not possible for you to state constitutionally, Millers, that 370 notification or under sub-article 3 will justify the action taken, which is 272 and 273, which has nothing to do with the notification. If you uphold 272 and 273, you will have to uphold it on its own terms, not on terms other than 270 sub-article 3 and the proviso, because that's what they have adopted. Even if you were to accept that argument, it's not possible for your Lordships, with the greatest respect to Millers, uphold the action under 272 and 273. And so I was, Millers, that's one thing I was saying. Now kindly see, Millers, please kindly see. And kindly see the absurdity of this. The absurdity is that when it comes to 371, B1 and 2, you have to consult, or you have to, the state has to concur. If it comes to 370, 1D, again you have to consult and or concur. When it comes to 373, you can abrogate without consultation, without concurrence. How can that interpretation ever be accepted by a constitutional court? Means that you don't need consultation, you don't need concurrence. You can unilaterally do it. For everything else, you'll need that. That's a constitutional absurdity. For individual articles, you have to concur, but for the whole abrogation, you don't have to concur. Even for a law, you have to concur, Millers. This is, I give the greatest respect, Millers, at least take the text and the context, Millers, not a pretext. Now, Millers, I just want one other thing. If you look at Article 371, notwithstanding anything in the Constitution, starts with it. You Article 371A, notwithstanding anything in the Constitution. And then 371A sub-article 2, notwithstanding anything in the Constitution. Then Miller's special provision with respect to State of Assam, notwithstanding anything in the Constitution. 371C, notwithstanding anything in the Constitution. The 368 will not apply to any provision of the Constitution in this chapter. Is that not against basic structure? If the argument is, at least I didn't argue the basic structure, but otherwise, that's also against basic structure. Why don't you set aside the entire chapter? Every provision other than one, which relates to Andhra Pradesh, starts with notwithstanding anything in the Constitution. Now, as far as Jammu Kashmir was concerned, they had an added protection, the proviso to 368. That constitutionally means that the complete merger that we are talking about, dehors the proviso, could never be done. There could be an argument as far as other articles are concerned. You may still apply, you should use 368. You may argue that. To what extent it will be upheld or not is a separate issue, because in some of these articles, even treaties cannot be changed. Some of these articles have treaties, Mullah, between the government of India, which was entered into in the past, cannot be changed. So whether 368 will apply or not, we are not into this. I'm just getting you the scheme, Mullah. So Mullah, I'm done with this. Now, Mullah, I come back to my try and finish as quickly as possible, because a lot of eminent counsel are waiting for me to finish, which I wouldn't wish to do, Mullah. I want to. Now, Mullah, just one other thing before I move on. Show me the. No. Give me the. Looks at my note, Mullah. Your Lordships don't mind, which is now rejoinder. Yes.
What page is it?
Mullah, that is a rejoinder. I don't know.
What page of the rejoinder? Rejoinder we have.
Page, I'm just giving you a lot. Page, Mullah, kindly come to 23. Where is that interpretation? I'm sorry, Gopala Swami. Sorry, Mullah, 17. I'm sorry, I apologize.
17.
16. Starts at 16, but at 1-7.
Yes.
Now, Mullah, your Lordships will see the centrality of this, that he is part of the drafting committee. He is, Mullah, piloting the bill. My Lords, has it, Justice Vivekanand?
Yes.
Now, just see, Mullah.
This we have already.
No, just one last sentence, Mullah, of this. But before he issues any order of that kind, that is under 373, the recommendation of the Constituent Assembly will be a condition precedent. That explains the whole of the article.
That's been noted.
No, that's the understanding throughout, Mullah, till 5th of August. And our interpretation is consistent with it, and their action is consistent with it, which we are now challenging. So that was one. Then, Mullah, now I come back to that argument, Mullah, that I made yesterday. That once the dissolution took place, 356 could not have been imposed as a matter of law.
That point to make.
And if 356 couldn't have been imposed, all that happened by virtue of the power under 356 is all illegal and void. Because the structure of the Jammu Kashmir constitution is entirely different. My Lord knows that any act of dissolution has to be done on the aid and advice of Council of Ministers. That applies not just to Jammu Kashmir, but to the rest of India. No dissolution of an assembly can take place without the aid and advice of the Council of Ministers. Therefore, Mullahs, constitutionally, the dissolution on the 1st of November was void. And you can't interpret the act of the governor and the powers of the governor and the responsibility of the governor different from other states in India. That as far as governor of Jammu Kashmir, he can do it, but the rest of the India, governor cannot do it because the provision is the same. So if that action is bad, 272 has to go. 273 has to go. And even if you assume that action is good, you can't exercise this power under 356. So 272, 273 will still have to go. Because the power is only the power to make law. You are the delegate of parliament, of the legislature. You can only make law. You can't change Article 3. And whereas my learned friend, the learned Solicitor General, cited several instances of 356 where Article 3 is suspended, but not with reference to the change of Article 3. That's the usual procedure that was followed. But not to change Article, to amend Article 3. That is never the power given. And that is apparent in 357 subclause 2, Malas. Kindly see 357 now. It's in my note itself, Malas. I'll just give your lordships the page. Page 25, PDF 25. Yes. Kindly see. Para 60, Malas. My lord has, all my lords have 357 sub-article 2.
Yeah.
Majestic Gawai has it, Malas. This is 25. PDF 25, 357 2. 357 2. Any law, Malas, as applicable to Jammu Kashmir. That's very important. Any law, I'm sorry, Justice Khanna. Any law made in exercise of power of the legislature of the state by parliament or the president or other authority referred to in subclause A of clause 1, which parliament or the president or such other authority would not, but for the issue of proclamation under 356 have been competent to make, shall, to the extent of the incompetency, cease to have effect on the expiration of 1 year after the proclamation has ceased to operate. So how could 272 be issued? Any law made has to expire after 1 year under the Constitution of Jammu and Kashmir. One of the distinguished counsel on the other side didn't read this part. He read Malas 357(2), which is different, which is the Constitution of India. Any law made in exercise of power of the legislature of the state by parliament or the president or other authority referred to in subclause A of clause 1, which parliament or president or such other authority would not, but for the issue of a proclamation under 356 have been competent to make, shall after the proclamation has ceased to operate, continue in force until altered or repealed or amended by a competent legislature. So how do you, Malas, amend Article 3 of the Constitution and justify it? Either under 356 or under 357, because the legislature has the power to set it, to make law. How do you then do it? And that also temporary emergency laws, remedial laws. It was original 350s.
Just read the last portion once again.
Yes.
One, it says law made. Is it talking about legislation made, legislation in form of laws or enactment
Yes, yeah.
made, and read the last part.
Last part, which shall so cease
Yes.
to have effect as are sooner.
To have effect on expiration of period after the proclamation has ceased to operate,
That's correct.
except as respect to things done or omitted to be done before expiration of the said period.
Yes.
This part will have to be explained. Unless the provisions which are so ceased to effect are sooner repealed or reenacted with or without modification by act of appropriate legislature.
That's correct. So, Manas, how can that appropriate legislature, when it comes into being, ever do this?
Just two things, Mr.
Yeah.
Sibbal. One, is it dealing with laws made and not with the effect of, will it apply also to Article 370? Or for that matter,
Once there is,
Article
once 356 is there, it will apply.
Yes, we are not, it's a matter of interpretation.
Yeah,
It's not a matter of taking sides.
I agree, Mullah. I'm not taking sides. I'm only taking my side, Mullah.
You are doing that.
Yes, that I'm entitled to take, hopefully, Mullah.
One, it says law made. Will it also apply to the power exercised by the legislature in terms of the constitution? One aspect. The second is, to the extent of incompetency,
Correct,
cease to have effect on expiration of period of 1 year
correct,
after the proclamation cease to
right,
operate, except as respects of thing done or omitted to have been done before expiration of that period.
correct,
So what it also protects is whatever has been done or omitted to be done before expiration of that period
correct,
will be protected.
correct, absolutely.
Will this not get covered in that part?
It won't, because this is an amendment of the Constitution. It's not a law.
Then you aren't contradicting yourself.
I'm not. It's not a law. This is not a law, Mullah. This is an amendment to the Constitution.
So what it talks about is laws, not.
No, because you're a delegate of parliament, of the legislature. In other words, whatever power the legislature has to make laws, you can make laws. Mullah's 356 is not an omnibus position to Mullah's take over the legislature and do what you like.
Mr. Sibal, when we interpret, we have to interpret the section without taking, you may say in the contextual interpretation, we have to take the whole background.
I'm sorry to say that's covered by Bomai, Mullahs. That's not covered, that's not, there's no cavil to it. That's covered by Bomai. And I've cited all those passages of Bomai to your lordships already.
Just one.
Let's not find any other power. That's non-existent. The temporary provision.
Second part.
But Mumbai 153 4C.
Says, when we interpret, especially because your lordships interprets the Constitution, we only make arguments. It's for posterity. It's not for this case or that
Yeah,
case.
you don't have to remind us.
Your lordship knows that. If you give such a
No, I
power
think-
to Parliament under 356, your lordships, anything can happen. Anything can happen. And as I said that the other day, and I'm digressing a bit, with respect to Maharashtra, I said, if Maharashtra is upheld, it will happen again. And it happened in Maharashtra itself. Because we have to protect the Constitution. We don't have to do anything more than that. Our at both sides, Mullahs, endeavors to protect the Constitution. And your lordship upholds it. That's our task. And upholds it for posterity, not for a particular case.
357(2) of the Constitution of India.
Yes, I will. Which was, I'm sorry, PDF. I got it, yes. Yes, I will. has ceased to operate, continue in force until altered or repealed or amended by the competent legislature or other authority. That's right.
What's the difference between the two?
Difference is that is 1 year.
1 year.
Yeah, that's only, that's.
And protection, whatever is.
Yes, in other words, the
done, that's
legislature can
permitted to be
undo
done.
it. The legislature, because it's been a delegate, before parliament is a delegate.
But in both the cases, it's law made and exercise the power of legislature.
Yes, absolutely. That if this is a law made, if your lordships believes it's a law made, then within 356, because 356 is to restore democracy and it's only a temporary measure. Right? And Malat, not only that, you cannot take irreversible action. That also is decided by this court. That during this time, unless your lordship knows the difference between state of Rajasthan and Bomai. In state of Rajasthan, they said, in Bomai, they said, you must dissolve after the proclamation has been accepted by both houses of parliament. You can't do it before. Until there's suspension, which is what I was saying yesterday to your lordships. Now that's irreversible. Therefore, Bomai said you can't do it. Rajasthan said it's possible before approval. Bomai disagreed. That can only happen after approval. But here what happened? It happened before. And it happened without aid and advice. That's even worse. I could have understood if the governor has sent a report way back on 20th of June. I could have understood then. But not in this fashion. Therefore, the whole motive was political, and I've been saying that from day one. The motive was political, the process was political, but the end result was unconstitutional. And Malas, I've already pointed that out. Let's not take more time with the court. What did Malas Ambedkar ji say? He said, I cannot altogether deny that there's a possibility of these articles being employed for political purposes. So what I've said before your lordships is no different from what Ambedkar ji said. His fears have turned out to be right. So, therefore, now let's kindly come to now. Now come to the argument. I've done with the dissolution part. I've done with 356. Your lordships have read all the judgments, I'm not going to repeat anything. Now I come to the argument of impossibility. An argument not raised, not part of the counter affidavit, not part of any pleadings, not part of any proclamation, not part of arguments the last time also, not part of the first set of written submissions, and yet we have to deal with it. Now, let me tell you also the principle of impossibility, constitutional principle of I'll just enunciate it. If there is a constitutional obligation to be performed, and it has to be performed, then in furtherance of that constitutional obligation, the principle of impossibility of performing another obligation comes in. Give your lordships an example. The term of the assembly is 5 years. Assembly is dissolved in 4.5 years. There is no assembly. And the judgment my learned friend cited, there is a presidential election or election of the vice president, and members of assembly have to vote. But the term of the assembly expires in 5 years' time. The constitution says you have to perform that obligation. So if the assembly is in dissolution, it's impossible for them to vote. That's the constitutional principle. Where is the obligation under 370? It has to be stated in the Constitution. You can't silently invoke it. And 376 probably free bail may, not shall. There is no obligation. That's the principle of impossibility, which has absolutely no application. How is it impossible, Malad? Why is it impossible? No, you've made it possible by acting that the way you've done. That's the way to do it, Malad. Now, whether that's constitutional or not is a different issue. But it's certainly not impossible. If you uphold it, it's not impossible. If you don't uphold it, it's only unconstitutional. Beyond that, your lordships are not asked to decide. So where is the question of impossibility? That's my answer, Malad. And the judgment that my learned friend cited, Malad, what's that judgment? In a presidential election is exactly that. Namely, the election had to take place, voting had to be done, the assembly was dissolved. So how could they have voted? The proclamation was there. So that's the constitutional principle. That's it. Anything else? No. They have already. Very quickly, I'll take about 10 more minutes and I'm done. Now, kindly come to 272. Where is it? Page 27, PDF, page 27. Volume? Yes, my rejoinder, PDF 27. I mean, it's just, I've already argued it, Malad, that this is all beyond, Malad, the powers of the president. And in any case, he has to act on the aid and advice of the Council of Ministers. So it's Parliament also has nothing to do with it. And Malad, it doesn't need concurrence, doesn't need consultation. That argument I've already made. And if that can't be done, Malad, then we're left with nothing. Then 273. Huh? No. Let's 273 now. But let's also kindly note. Nothing else. Oh, one second. 36. Well, let's kindly come to my the 367 argument that was made. The interpretation part. And then they relied upon Damnu, Malad. That argument has already been made. I'll not repeat it, Malad. Damnu itself says that this particular change at that point in time was not a change in the substance of 370. In the Jammu Kashmir constitution is applicable, the word governor was already there. And therefore, you couldn't have interpreted it in any other way. So that's all, Malad. It's already been argued. Now come to Malad to Article 3. PDF 33.
Yes.
So, Malad, as far as Article 3 is concerned, Malad, let's assume I've made my arguments on the proviso already, Malad, that under 356 it can't be done. But now let's assume the proviso is not there. Let's assume that, Malad, all this is valid. Let's assume. Malad, how can they make the union, a state into a union territory? Under what provision of law? Okay, under what power? Then my Lord put to them that there may be a situation of a national security situation. So therefore, temporarily, you may need to do that. But the national security situation is dealt with by Article 352 of the Constitution. 352 to 359 deals with all this. So how can you use Article 3 to do that? You can't use a power in 3, and of course that's not their case also. It's nobody's case that this was being done because of national security. Pulwama happened, Malaj, in February 2019 during President's rule. And then they had elections in May 2019. And what is the justification of keeping, not constituting the state, Malaj, for 4.5 years? Under what constitutional basis can you say that I will keep a particular state as union territory for 4.5 years? You say you are going to have municipal elections. You're going to have local government elections. There are a number of, the tourism has increased. So what's the impediment then? What's the constitutional logic, Malaj, or basis on the basis of which you can deny the people of Kashmir a statehood, and Malaj, India is a union of states. As your Lordship rightly said, my Lord the Chief Justice, that a union territory can get the status of a state, but not the other way around. It's never happened in the history of this country. Actually, 272, 273, all this has never happened in the history of this country. Not even during emergency. So, Malaj, just one last thing, and then I'm done. I want to show you the annexures in this, Malaj. This is my argument on 3, Malaj. Others will deal with it in some form. I want to show just one. Yes, kindly see PDF 42. Now, this is dated 17th May 1949. Well, as your Lordship will notice here, and this is all documents are provided in the annexures, that at this point in time, Iyengar, Sheikh Abdullah, and Vallabhbhai Patel and Nehru were all getting together to draft 370. And on 17th May 1949 is a letter written by Gopalaswamy Iyengar. And he tells Vallabhbhaiji, here's the draft. Jawaharlalji has seen and approved of it. Will you kindly let Jawaharlalji know, direct as to your approval of it? No, directly tell him as to your approval of it. He will issue the letter to Sheikh Abdullah only after receiving your approval. Vallabhbhai Patel was the architect of 370. Nothing was done without his approval. In fact, he went to Parliament. Kindly see, there's another letter, another document here. 3rd November? Yes, it's very interesting with us. 3rd November. No, not 3rd November. No, yes, 3rd. Yes, where is it? Yes.
But look at Sardar Patel's letter at page 47, 46.
46, yes. Correct. That's the draft, Malaj, of 306A. Kindly come to 244, Malaj.
Right, that's that letter.
Thank you for your letter of 15th, which I have received only this afternoon on my return from the constitution. One second. I find there are some substantial changes over the original draft, particularly in regard to the applicability of fundamental rights and directive principles. You can yourself realize the anomaly of the state becoming part of India and at the same time not recognizing any of these provisions. I do not at all like any change after our party has approved of the whole arrangement in the presence of Sheikh Saab himself. Whenever the Sheikh Saab wishes to back out, he always confronts us with his duty to the people. Of course, he owes no duty to India or to the Indian government or even on his personal basis to you and the Prime Minister, who have gone all out to accommodate him. In these circumstances, any question of my approval does not arise. If you feel it is right thing to do, you can go ahead and do it. Now see the next document, 3rd November. There was some, again, this is by Vallabhbhai Patel. There was some difficulty about the provision relating to Kashmir. Sheikh Saab went back on the agreement which he had reached with you in regard to the provision relating to Kashmir. He insisted on certain changes of a fundamental character, which would exclude in their application to Kashmir the provisions relating to citizenship and fundamental rights and make it necessary in all these matters as well as others not covered by the accession to 3 subject to seek the concurrence of the state government, which is sought to define as the Maharaja acting on the aid and advice of Council of Ministers appointed under the proclamation on 8 March 1948. After a great deal of discussion, I could persuade the party to accept all the changes except the last one. He was the one who was interacting with the party. And he was the one who finally, Malats, persuaded the party to accept all the changes except one. And of course, Sheikh Abdullah thereafter.
Sure, there was a political compromise to ensure
That's all.
enough flexibility at later point of
Absolutely.
time.
All I'm saying is,
But
Malats, everybody
there's
was
another
part of
part,
that process.
You are accepting the second part also, that there was flexibility to ensure that in future it works itself out.
That's correct. Well, all that I'm saying is, Maharaj, they were all collaborating. The key players were collaborating in drafting 370, and this is how they understood 370.
That argument you have already.
Yeah, I've already made. I'm not repeating it, Maharaj. I just wanted to read these letters. So, Maharaj, and then I've got this table, Maharaj, of Jammu Kashmir, Maharaj, where Jammu Kashmir is the head of most of the states in India in every parameter. But we are not concerned with that, Maharaj. I just put it. So that's all I have to say, Maharaj. I just want to say at the end that, Maharaj, as I said, Maharaj, your lordships, Maharaj, ultimately is the arbiter of what this constitution should look like and how it's to be interpreted. But I only want to request your lordships to think of one thing, that as I walk out in silence of this court, let the court speak on behalf of the people of India. Because this court, this government, or any government, any administration acts for the people of India. And it should not be that acts are done when a part of the people of India are silent, who have never been consulted, and whose fate will be decided by the cabinet sitting here without reference to parliament, without reference to legislature, without reference to the people. Those people are central to the Constitution of India. We should not forget that. Thank you very much for giving me this time. Excuse me for a while, but let's fill it up.
Mr. Subramaniam, you'd be arguing.
Yes, my lord. My lord, am I audible? Am I visible?
Both, Mr. Subramaniam.
Yes.
Thank you, my lord. My lord, I just want to make a few brief submissions on Article 370 in the light of your lordship's questions and observations. My lord, it might have begun as a temporal provision initially. I don't think anybody can dispute that people envisaged it as of temporality. But, my lord, the provision had adequate evidence, intrinsic evidence in its words to suggest that it could be there to stay. And that is what has happened. And my lord, this is the crux of the matter. Has it happened in a manner known to Article 370? My answer, my lord, is yes. In a manner known to Article 370, Article 370 stays. Now, my lord, how has this been achieved? As your lordships would notice, that it was a Constituent Assembly of India which gave the people of Jammu and Kashmir the ability to determine their political future through a constitution. The instrument of accession, my lord, did not completely transfer sovereignty, as held by Justice Gajendra Gatkar in Pramnath Kaul's case. The instrument of accession itself had reservations that it was intended to abide by a future constitution, a future determination by the people of India, which is why Justice Gajendra Gatkar said that until the 1939 constitution was there, the Maharaja was still enjoying a certain kind of sovereignty to make laws, and therefore, my lord, upheld the law in question. Now, my lord, when does integration become complete is the question. And, my lord, in this case, unlike the cases of privy purses, unlike any other case, the sovereignty actually transfers from the king, from the monarch, to the people. And this transition from the monarch to the people is the common framework of both the Constituent Assembly of India and a Constituent Assembly to be formed. The notification of 25th November 1949, my lord, expressly uses the words Constitution as applicable, or insofar as is applicable, because that is how Article 306A of the draft Constitution presaged it. Well, on Article 306A is the only article which refers to the instrument of accession and refers to the matters contained in the instrument of accession as limiting the power of Parliament to make laws. Therefore, my lord, the instrument of accession expressly finds a place in Article 371 of the Constitution. The expression Constituent Assembly also finds a place in Article 370 of the Constitution. But there was a very important question which the Chief Justice has voiced on a few occasions. What is there to show that the Indian Constitution recognized a Jammu and Kashmir Constitution? I thought it was a very critical question, and I have, my lord, two answers. The Constitution does recognize the Jammu and Kashmir Constitution. May I invite your lordship's attention to the text of Article 370 itself that recognizes, my lord, that constitution. Please, my lord, look at Article 370 with me for a moment. In Article 370, after subarticle 1, 2, and if your lordship sees 2, if the concurrence of the government of the state referred to in para 2 of subclause B of clause 1, or in the second proviso to subclause D of that clause, be given before the Constituent Assembly. And may I request, my lord, your lordships to look at the next few words. For the purpose of framing the constitution of the state is convened. Constitution of the state, my lord, is no other constitution except the Jammu and Kashmir constitution. And, my lord, there is a second piece of evidence in the constitution which has not yet been brought to your lordship's attention. There was, my lord, the state reorganization in 1956. The concept of Part B, Part C, all of them disappeared, if your lordships recollect. The Constitution's 7th Amendment Act, my lord, in Article 152, inserted the words excluding the state of Jammu and Kashmir. In Article 152. This is, my lord, 7th Amendment. And, my lord, the dates are slightly significant. Very important, my lord, is the date. The 7th Amendment was assented, my lord, on the 19th of October 1956. And, my lord, by this time, the draft constitution of Jammu and Kashmir was introduced on 10/10/1956. And the draft constitution of Jammu and Kashmir established the High Courts of Record and established the legislature under its constitution.
What happened on 10/10/56, Mr.
In 1056, my lord, the draft constitution of Jammu and Kashmir was introduced for adoption. And that constitution, my lord, clearly had provisions for executive, the legislature, and the judiciary to be established in terms of that constitution. So institutions, my lord, were established under that constitution. And therefore, Part 6 was rendered inapplicable by the insertion of the words in the Constitution's 7th Amendment Act, excluding the state of Jammu and Kashmir. So, my lords, it was a very valid question that your lordships put to us. Is there any evidence, apart from conduct, which I'll deal with separately, in terms of constitutional conduct, that the Constitution of Jammu and Kashmir is alluded or is cognitively taken note of? It is alluded in the words in my submission in sub-article 2. It is cognitively taken note of because the chapter relating to Part 6 was rendered inapplicable under Article 152, which is why your lordships notice now the CO 273, it seeks to exclude that exclusion. It refers to 152. It says, notwithstanding anything in this constitution. So, my lord, I submit that the Jammu and Kashmir constitution does find a place. But let's come to a more critical point about the word recommendation in sub-article 3 and whether sub-article 3 was in fact employed. It's a very critical question your lordships asked. The word recommendation, my lord, was chosen consciously because the Constituent Assembly of Jammu and Kashmir, my lord, was not constituted by the Government of India or any initiative of the Government of India. It was under a proclamation of the Maharaja under the Jammu and Kashmir Constitution. That Constituent Assembly, my lord, was not an emanation of the Government of India's Act. Second, my lord, an order which had to be issued under Article 371 necessarily had to be an order in the name of the President. And that's, my lord, because all executive power vests in the President. The argument of President being answerable to Parliament, I'm sorry, my lord, with respect, is completely contrary to the decisions of this court with reference to the Westminster style of government which we have adopted, which Dr. Ambedkar on the 4th of November, when he introduced the Constitution, he spoke about the role of the President. And, my lord, I submit, under Article 81, the President, my lord, is a part of Parliament. I was a little surprised, my lord, to say the President is answerable. My lord, he is a part of the Parliament. Parliament, by very definition, includes the President and two houses, my lord. And under our Constitution, my lord, the President can never act without the aid and advice of the Council of Ministers. The governors could, under Shamsher Singh, but not the President. So, my lord, a claim of untrammeled discretion and power in the President under Article 371 itself, my lord, is flawed. But now, my lord, let's see how events have played out. Your lordships wanted to know, was sub-Article 3 employed? Was there anything to show that it was effectuated? And I say, my lord, it was effectuated in 4 different ways. The summum bonum of all the 4 steps is it was effectuated. And, my lord, the decision to abrogate Article 370 cannot be taken ad nauseam. It was meant to be taken once. It had to be taken by the Constituent Assembly. Now, my lord, let us look for evidence of it. The first is, please look at, my lord, CO. If your lordships will look at CO 42. Would your lordships kindly go to the documents volume for a moment? Please go to, my lord, document volume 3. And would your lordships kindly come at page 12 of the PDF. CO 44, I'm sorry, CO 44. Please see, my lord, this. My lord, this is on the recommendation of the Constituent Assembly. PDF 12, my lord. And if your lordship says this is a declaration under Article 373 of the Constitution, and if your lordship now sees the declaration, in exercise of the powers conferred by Clause 3 of Article 370 of the Constitution of India, the President, on the recommendation of the Constituent Assembly of the State of Jammu and Kashmir, is pleased to declare that as from the 17th day of November 1952, the said article shall be operative, with the modification that for the explanation in clause 1 thereof, the following explanation is substituted, which, my lord, is about the Sadr-e Riyasat. But, my lord, this is a decision under 373. What was the next decision? The next decision, my lord, was again a recommendation of the Constituent Assembly, namely an invitation, my lord, to apply the provisions of the Constitution of India subject to certain modifications. That was a decision, my lord, again of the Constituent Assembly. It was a resolution of the Constituent Assembly. And that, my lord, is significant because that resolution was on the 15th of February 1954. Your lordships will find that in volume D7 at page 978, and it was adopted in, my lord, D7, page 979. That annexure, my lord, which was the annexure attached to the report of the drafting committee, was tabled in the Constituent Assembly.
Where did we get it? At page 2,
My lord, volume D7. Has your lordship a volume D7?
PDF?
Yes. My lord,
979.
could your lordships first see volume D7 at page 937? Let me show you first.
937.
Yes, first 937, and then I'll show you, my lord, the resolution.
That's the report of the drafting committee?
Yes, this, my lord, was tabled before the Constituent Assembly. And in this report of the drafting committee, your lordships will notice at 938, PDF 938, would your lordships look at the first sentence? The provisions of the Constitution of India, which in addition to Article 1 and Article 370 should apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they should so apply will be as follows. And then, my lord, all these are extracted. But what's important, my lord, is Article 1 and Article 370 in addition. This, my lord, is introduced on the 11th of February 1954. And on 15th of February 1954, if your lordships go to page 978, my lords, of the same volume, this was adopted. So, my lord, the first body which looked at the matter was the Constituent Assembly. They invited the application of the provisions of the Indian Constitution. And at 978, your lordships will see at the bottom of the page. Please look at the bottom, my lord. Resolution that having adopted the report of the drafting committee this day, the 15th of February 54, and having thus given its concurrence to the application of the provisions of the Constitution of India in the annexure to the aforesaid report, this assembly authorizes that government of the state to forward a copy of the said annexure to the government of India for appropriate action. And that is how, my lord, on the 14th of May, 1954, the 1954 order was passed. And your lordships will notice the words of that order. It's in volume D3, my lord, at page 13. Your lordships will notice
Volume 3,
that,
page number, volume 3.
yes, volume D3, page 13, my lord.
Okay.
Your lordships will find an express continuance of Article 370. Please see page 13. This is the 54 order.
Yes.
And please come to 2. The provisions of the Constitution, which in addition to Article 1 and Article 370 shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall so apply shall be as follows. And, my lord, this order of 1954 was again tabled before the Constituent Assembly. If your lordships go to volume D7 at page 990.
Circle 371, not 373. No.
And at page 990, my lord, your lordships will notice that in the Constituent Assembly, the 1954 order is laid on the floor of the House. Please see 990, Mr. Dogra. The recommendations of the House in this behalf had been sent to the President of India, who in exercise of the powers conferred under Clause 1 of Article 370 was pleased to issue Constitutional Order 1954. I lay the copy of this order on the table of the House. As I told your lordships a little while earlier, the draft constitution, my lord, of Jammu and Kashmir was introduced by Mr. Dogra on 10/10/1956. Your lordships will find in the same volume at page 1058. In that same volume. Your lordships will see 1058 PDF.
Page number, please repeat.
Page number 1058 PDF, my lord, in volume D7. Otherwise, it has a red lettered page of 2417.
That's it.
And your lordships will notice, Mr. Dogra, sir, I beg to present the report of the drafting committee and introduce the draft constitution as settled by the committee. And your lordships may just see 4 lines later. The fundamental principle on which the draft is based are parliamentary democracy, responsibility of the executive to the legislature, joint responsibility of the cabinet, separation of the various powers of the state, executive, legislative, and judicial, and finally, the rule of law. One basic feature of the Constitution is that we have once again affirmed that the state is an integral and inalienable part of India and will ever remain so. There was a very thoughtful observation from my Lord Justice Gawai on Dr. Ambedkar's contrast of different models of federalism. But Dr. Ambedkar does say even the Indian Constitution shares sovereignty between the center and the states. However, it does not have the same nature of the American Constitution. It comes to an end there because they have separate constitutions for each state and they have citizenship for each state. But, my lord, here, the word which is used is only permanent resident, not citizen, my lord. All Jammu and Kashmir residents governed by that constitution claimed and asserted that they are Indian citizens. I'm going to show that, my lord, in a moment. Now, this, my lord, is the draft constitution. Now, would your lordships kindly come to 1910-56? You just have to look at Article 152 in your, my lord, in the constitution. Please have a look at Article 152.
What is the date, Mr. Subramaniam?
That, my lord, came on 19th October 1956. Your lordships will find that at page 101 of the Constitution, PDF.
That is the 7th Amendment.
That is the 7th Amendment, my lord.
And it came into force on 1st of November 1956.
Absolutely, my lord. And your lordships will notice the parentheses. This recognizes the J&K Constitution because the establishment of the Raj Pramukh or the governor or the institutions of the legislature, executive and the judiciary were undertaken under that constitution. So your lordships notice in the definition article 152, in this part, unless the context otherwise requires, the expression state and then does not include the state of Jammu and Kashmir. Now, my lord, the constitution of J&K was adopted after this. This is 1/11/56. The date of adoption of the Jammu and Kashmir constitution was, my lord, actually 17th of November 1956. And, my lord, in line with the date of coming into force of the Indian Constitution, they made the effective date as 26th of January 1957. And the J&K Constitution, your lordships will find, is in volume D2. And it is at page 17.
Volume D2.
Page 17, my lord.
Mr. Subramaniam, what seems to have happened was this. During the period when, after our constitution came into force on 26th of January 1950, Jammu and Kashmir was a Part B state. Now, in relation to the Part B states, Article 238 of the Constitution made provisions for modification of Part 6 of the Constitution.
Right, my lord.
Therefore, to the Part B states, Part 6 would apply with the modifications which were spelled out in Article 238. Article 371A, however, stipulated that
238 will not apply.
238 will not apply to the state of Jammu and Kashmir. Right? Now, that was that period when the constitution was yet to be drafted. After, with the 7th Amendment, Jammu and Kashmir ceases to be a Part B state. It becomes a state within the meaning of Article 13A of the Constitution.
Right,
The distinction between Part A, B, C, and the Part D territories vanishes after the 7th Amendment. So when Jammu and Kashmir ceases to be a Part B state, automatically some provision had to be made. It was not governed by Article 238. So other Part B states, which ceased to be Part B states, were governed then by Part 6. Jammu and Kashmir was not within the fold of Part 6 for the reason that so long as the Jammu and Kashmir Constitution continued to hold the field, That constitution made provision for the executive,
Yes.
the legislature, the judiciary, so on and so forth. So this provision in Article 152 was in continuum.
Exactly.
Because from the inception, Article 238 had no application. And
Right,
once it came within the fold of not a Part B state, you had to make some provision. Now that provision, according to you, was made in the Constitution of Jammu and Kashmir.
My lord, absolutely. This is the point I'm making.
Right, but that doesn't tell us the basic question as to whether that was intended to be a permanent arrangement.
Yes. Now, my lord, for that purpose, if your lordships now take the Jammu and Kashmir constitution, because, my lord, that's a little important. Your lordships are absolutely right. We have to look for evidence in the instruments themselves. Let's look at the constitution of Jammu and Kashmir. Because the Jammu and Kashmir constitution, my lord, actually not only makes integration absolutely beyond any pale of doubt. Unity and integrity with India is beyond a pale of doubt in that constitution. It, my lord, reserves provisions for the application of the Constitution of India in the state of Jammu and Kashmir. My lord, that's quite significant. If your lordship just takes that for a moment, please look at, my lord, their preamble. Because, my lord, what we are concerned with in this case, we have used different expressions like consent of people. We have used the expression people. But, my lord, let us look at their preamble. This constitution was inspired, quite rightly, as my lord the Chief Justice said, by various constitutional provisions. And, my lord, it was many of the exceptions in the 1954 order were also inspired, my lord, I'm going to show to you shortly when we come to Parathe's case, by the American Constitution. But I'll show that in a moment. Please come to the preamble. We, the people of the state of Jammu and Kashmir, having solemnly resolved in pursuance of the accession of the state to India, which took place on the 26th day of October 1947, to further define the existing relationship of the state with the Union of India as an integral part thereof, and to secure to ourselves justice, social, economic, and political. Well, look, this word, justice, political, will be of some significance in the light of Dr. Ambedkar's own exposition. This is, my lord, a resolve, and therefore they adopt this constitution. What is now, my lord, important is the Constitution of India, and which your lordships will notice is in 2(1)(a). At page 17. The first definition, my lord, is for the Constitution of India. Constitution of India means the Constitution of India as applicable in relation to this state. And then your lordships may kindly see 3, 4, and 5. Three is relationship of the state with the Union of India. The state of Jammu and Kashmir is and shall be an integral part of the Union of India. Well, Lord, this is a part of a constitution. What is the further integration we are talking about? It is an article of faith. It is a parchment of pride. For the people of Jammu and Kashmir, they have set this in the forefront in Article 3, which is called Section 3. by commentators. Then please see 4, the territory of the state shall comprise all the territories which on the 15th day of 1947 were under the sovereignty or suzerainty of the ruler of the state. And 5, my lord, please notice 5. The executive and legislative power of the state extends to all matters except those with respect to which Parliament has power to make laws for the state under the provisions of the Constitution of India. But, my lord, under the provisions of the Constitution of India as applied under an order under 371. And, my lord, thereafter, your lordships will
Therefore,
notice
so
section
Subramanian,
6, sorry.
The domain of the Constitution of Jammu and Kashmir was that which was defined by the Constitution of India.
Yes. Now, my lord, I'm now saying Constitution of India here meant.
Therefore, this was
Yes.
not that. This was not therefore a constitution which was at par or superior to the Constitution of India. It can't be superior to the Constitution.
No, it is not superior. My lord, it's not superior.
Nor was it at par with the Constitution of India, for the reason that, look at the two definitions, 2(1)(a).
Yes.
Constitution means the Constitution of India as applicable in relation to the state.
Yes, my lord.
Now, where would we find the nature of the application of the Constitution of India to the state of Jammu and Kashmir? Not in the Constitution of Jammu and Kashmir, but in the Constitution of India.
Agreed. Agreed,
Right.
my lord. That is why your lordships are right.
Right.
Under section 5.
Right, section 5 also.
Yes, under the provisions of the Constitution.
Legislative power of the state extends to all matters
Yes.
except those with respect to which Parliament has the power to make laws for the state under the provisions of the Constitution of India.
Correct, my lord.
Therefore, the domain of Parliament to make laws for the state would be defined by the Constitution of India, not by this Constitution.
I'm grateful, my lord. Now I'm taking you a little closer to the point that if it meant under the Constitution of India, it also meant the order under 371. That's the point I'm making. And, my lord, that way, there is nothing in this case, my lord. The two constitutions are, I'm not saying this is superior. Please don't get me ever wrong. But, my lord, I would not like to say easily that it is inferior because it has established courts of record and a legislature. It's a constitution, my lord. The Jammu and Kashmir High Court owes its existence to this constitution. The legislature of Jammu and Kashmir owes its existence to this constitution. They have been established, my lord. These are institutions of a permanent nature established under the constitution.
Who would
My lord,
appoint
there is
judges
no
to the
question
High
of
Court of Jammu and
superiority.
Kashmir? Who would appoint judges to the High Court of Jammu and Kashmir?
Well, that also is provided. The Chief Justice is involved. The Chief Justice of India is referred to. This constitution, my lord,
President would
refers.
appoint judges to the High Court of Jammu and Kashmir.
Yes,
The President would transfer judges from the High Court of Jammu and Kashmir.
yes. But, my lord, I'm saying the establishment of the institutions or their genesis not to the Indian constitution per se, but to the J&K constitution. My lord, I'm on the establishment of the institutions. Thereafter, they're administered naturally by the Chief Justice of India when appointments are made. But the important point, my lord, is that this constitution creates institutions. But in areas where it allows the Indian constitution full play, it is silent. It creates its institutions. It is, my lord, an additional act of affirmation. But that is what our Constituent Assembly did, my lord. Imagine, my lord, our Constituent Assembly in its wisdom gave space, gave a certain sense of choice to people to determine. My lord, I think nothing could have been greater than that. And likewise, the response of the people of Jammu and Kashmir in their Constituent Assembly, they matched it. They have matched it with the words of this Constitution. And my lord, this Constitution is also a parchment of pride, my lord. It defines them. It defines their persona. And they are not saying anything else. They're saying it cannot demise. A constitution, my lord, cannot demise. A constitution, my lord, cannot evaporate or eviscerate. Unless, my lord, it is done in a manner known to law. So, my lord, sub-article 3 of Article 370 worked itself out. It was meant to be acted on. They acted on.
You see,
Yes, Mr.
Yes.
Subramanian.
My lord, I wanted to point out, my lord, they even kept out of their amending power in section 147 of the Constitution at PDF page 85. Your lordships will notice section 3, 5, and the provisions of the Constitution of India as applicable, they will never touch. My lord, I don't think the resolve of people is clearer than this. The resolve of a constituent assembly cannot be clearer than this. That they celebrate the unity of India and they say, we will never touch it, will not amend.
Mr. Gopal
Section
Subramanian,
3.
on one aspect, there is no less at all, is as far as integration into
Yes.
the India is concerned, there is, I don't think any of the sides are at item. So that we accept, that's a prime That's the foundation on which we have proceeded.
Yes,
And then the issue has arisen with regard to Article 370.
yes,
The making
right.
of the Constitution of J&K will be also, or Constitution of India as applicable to J&K,
that's right.
dedicated and from on the basis of Article 370.
That's right, my lord. So now we look at the other two points about the validity of these two actions. Once, my lord, we are clear that the provisions of the Constitution of India as applicable in relation to the state can never be changed, my lord, this is called an acknowledgement in a constitution. It's a total acknowledgement of the Constitution. And, my lord, the question which arises for your lordship's consideration is, if the Constituent Assembly of Jammu and Kashmir and the Jammu and Kashmir Constitution paid such and accorded such supremacy to the Constitution of India, we are now, my lord, coming to the question which Justice Khanna posed, what about the powers under 370? We're coming straight to the point, my lord. What about the powers under 370? My lords, I am not looking at the inconsistencies in the government of India's pleading. I will assume that they can argue anything as long as they can show power and its valid exercise. Let me assume that they can raise any argument, but let them show where is the power and where is the exercise. Now, my lord, let's start with the first. It was suggested that Article 367 was a route. The amendment of Article 367 was a route because we have done it in the past. We have done it once more. Very simplistically put. But, my lord, when was it done? It was done, my lord, in 1954 in CO 48. It was done in 1958 in CO 56. And it was done a third time, my lord, in 1965 in CO 74. Now, my lord, your lordships will be a trifle surprised to know that the modifications to Article 367 in CO 48 and 56, 48, my lord, is at volume D3, page 13, and CO 56 is volume D3, page 25.
Page?
My lord, they provided these two orders when it amended Article 367.
D313 and D325.
Yes, D3, page 13, my lord, and D3, page 25.
Okay.
And if your lordship sees it, my lord, Article 367 was to provide for definition for terms which appear in the order. Please look at it for a moment.
25. That point you made, Mr. Subramaniam?
My lord, that is the amendment proposed in 367 was to define terms in the presidential order. The first two. If your lordship sees 13, my lord, for a moment, I can just demonstrate it straight away. Please come to page 13, my lord, it starts. Please come to 18.
Yes.
For the purposes of this constitution as it applies in relation to the state of Jammu and Kashmir, references to this constitution or to the provisions thereof shall be construed as references to the constitution or the provisions thereof as applied in relation to the said state. And your lordships will find references to a high court shall include references to the High Court of Jammu and Kashmir. Reference to the legislature of a legislative assembly shall be construed as including references to the constituent assembly of the said state. And, my lord, likewise, the 58 order, CO 74 of 1965, my lord, please take the dates. It's a little important. The 1965 order was preceded, my lord, by the J&K Amendment, Constitution Amendment Act.
Was preceded by?
It was preceded, my lord, by the Constitution Amendment Act of 1965, my lord, that was enacted on 10th of April 1965. Sixth Amendment Act. And, my lord, the CO 74 in Damnu's case was issued on 24/11/1965. Now, my lord, we come to the question about the power under 370. My lord, any power under the Constitution, my lord, is not untrammeled because we have a controlled Constitution. We have to see whether the power is exercised for the purpose for which it was conferred. And if that purpose, my lord, implies, as my lord the Chief Justice perspicaciously pointed out, either consultation or concurrence, or, my lord, in a one-time decision, a decision of the Constituent Assembly, it is very clear that Article 370 itself negates unilateralism. It actually is widely worded, but it still, my lord, involves the state, it involves the legislature, it involves the Constituent Assembly. Mr. Sybil, my lord, is perfectly right when he says that those who have actually lived by the sword of the proviso and have taken recourse to Article 367, they must actually be tested on that basis. But, my lord, I am going to deal with the argument fully. But I'm going to put it in very simple words. First was, you can ignore the proviso. Second was, what is this word recommendation? It's a recommendation. You are the ultimate. You're the president. But, my lord, recommendation of a Constituent Assembly in a context in which that word is placed in sub-article 3, my lord, tells us that it is a condition precedent. Gopalaswamy Iyengar definitely called it a condition precedent, but, my lord, on principles of constitutional construction, you would be justified in interpreting it as a condition precedent, which means, my lord, if that condition precedent was not satisfied, the power was unavailable. This is not a normal proviso. And my lord, marginal notes with great respect. After Keshavananda Bharati, all the learned judges said it doesn't control a constitutional provision. But I'm starting, my lord. Yes, we thought it was temporal. But by the will of people, it became a mainstay. Now, my lord, there was also a suggestion. There is a power coupled with a duty to abrogate Article 370 because of this marginal note. My lord, power coupled with a duty can sometimes be implied. But here, it is a self-contained code, Article 370. The duties lie within Article 370. The assumption of a duty, my lord, outside the Constitution is never permissible.
Mr. Subramaniam, I think we have given you sufficient time in a rejoinder now.
Yes, my lord, I'm quickly galloping.
Yeah.
My lord, I can't look galloping, but I'm galloping. I'm galloping, my lord. I wouldn't necessarily, my lord, inflict on you a little more than needed. No. My lord, I'm only referring to the nature of the arguments with reference to marginal notes, with reference to the proviso, and I'm saying, my lord, that they are completely untenable. But, my lord, there is also something which must be brought to your lordship's notice. There was this 1952 agreement. We all had a summary. We were looking for something more authentic. Then my Lord Justice Gavai rightly said that, well, it has at least been introduced by the Prime Minister of Jammu and Kashmir in the Constituent Assembly. My Lord, this was also introduced by the Prime Minister in Parliament, the 52 agreement. And your lordships, I'm just giving the pages only the pages. It is in volume D9. The relevant pages are 53, 54, D9. My lord. These are parliamentary debates, 53, 54, 55, and 96. Now, my lord, I come to Parate's case.
These are the parliamentary debates on?
On, my lord, the 1952 agreement. There was a motion. It was brought to the House, my lord. It was discussed before Parliament. And of course, my lord, it's a pretty long speech, but the Prime Minister spoke about this agreement, and they seemed broadly an item with what Prime Minister of Jammu and Kashmir said. Now, my lord, we come to 2 points, and I'm finished. Article 3, Babulal Parate. My lord, Babulal Parate's case is distinguishable. That, my lord, is to be found in Case Law Compilation 6 at page 124.
124.
Yes. And what is significant, my lord, is Justice Das says in Article 3, we do not have a similar provision like the corresponding article in the American Constitution that the consent of a state legislature is necessary. This is very important, my lord. This is what Justice Das observes correctly. And now, my lord, if you see the 1954 order and the proviso to Article 3, it is precisely that provision in the American Constitution.
You are at page?
Page, my lord, 121 at 124 in volume C6. And then, my lord, I now deal with one point quickly, which is privy purses. My lords, there is no analogy between privy purses in this case. Privy purses, my lord, is a case of ex-rulers. Here, my lord, sovereignty passed on to the people in Jammu and Kashmir already. And even the judgment, which has been relied upon very heavily, my lord, which is Raghunath Ganpat Rao's case in volume C7, 537 at 562, my Lord Justice Pandian speaks glowingly about one basic feature of the Constitution called political justice, political rights. Political justice and political rights, Justice Pandian says, has not been touched by the Constitution 26th Amendment. Well, on that very passage, I rely upon to say, in our case, what we are dealing with, my lord, is not only the Constitution, we are also dealing with the class of rights which have been guaranteed to people in Jammu and Kashmir, both under the Indian Constitution and the Jammu and Kashmir Constitution. I would therefore, my lord, respectfully submit that the outcomes of integration, my lord, have been achieved. We may have different perspectives on it, my lord, but we are now only dealing with the validity. And my lord, 356, with very great respect, my lord, is never intended to use for the purpose of usurping state legislatures as bodies ear nomine by Parliament. No, my lord, it cannot be done. That notional vesting of power, my lord, is limited for a small purpose under 356. 370, my lord, is not a purpose which is intra-virus 356. It is alien to 356. And in any event, my lord, 370 says, notwithstanding anything contained in the Constitution, which gives it a certain degree of immunity. My lords, any questions? I'm ready.
Thank you. Thank you, Mr. Subramanian. Thank you very much.
Thank you.
Mrs. Zafisha?
May it please the Lord. It's a pleasure to hear, Lords, the counsels on both sides on various controversial issues which have arisen in the case. What I see is that several issues have been raised in this matter, and the court ultimately is to decide whether this CO 272 and 273, whether they're constitutionally valid or invalid. That would be the direction of the court, and that would be the ultimate decision of this court, whether they need to be sustained or quashed. While making the submissions, Lords, the councils have made at a different level of abstraction as to what possibly could be the grounds on which these two orders can be quashed. My approach would be to go on more fundamentals, the basics of it. The first premises, which to my mind is extremely important, is the existence of the state of Jammu and Kashmir at one point of time in history, and the formation of the Union of India at the same time in history. While as the India was being unionized. Jammu and Kashmir state by itself was not a part of India, neither it was a part of British India. Now we have it clear from the various statutes itself, whether it's Government of India Act or whether it's Indian Independence Act. That state of Jammu and Kashmir not being a part of the Union of India at that point of time, nor was a part of British India, it was altogether an independent state. It had its own king, it had its own country, and it had its own laws. The king at that point of time would run the affairs like any other king of any other princely state would do. And the king of the state of Jammu and Kashmir, I will not go back too much in the history, also had certain laws which governed the running of the government. Either the state subject definition, which was introduced way back in 1927 and 1932, which applied only to the people who were residing in that state. Or from time to time, as has happened in all countries of the world, there have been changes, democratization has taken place, and ultimately the Constitution Act of 1939 was also promulgated by the king. And he created certain institutions in them, supposed to be democratic, but at the same time, he retained all the sovereign powers with him. This was the situation with us. Now, when instrument of accession executed, the circumstance in which it was executed have been already said. They are evident from the letter of 26th October 1947. What is the nature of that instrument of accession has already been read. What was retained and what was transferred or donated to the Union of India. And the subsequent letter of the Governor General dated 27th of November 1947 has also been read, saying that we'll put it to the people of the state whether this instrument of accession is acceptable to them or not. These are facts of history. Having said that, thereafter, after 26th of October 1947 till 26th of January 1950, we have no other document evidencing as to the relationship of the state with the union, except this instrument of accession. What was sought to be stated by the respondents was that there was this proclamation of 25th of November 1949. The Constitution of India itself was adopted on 26th of November 1949, a day before. That has also been read today morning, and it was read earlier also. It said nothing except that the Constitution of India, as may be applicable to the state, would be acceptable to us. At that point of time, it was the successor of the king who was in chair, holding the position of the Maharaja. So when the Constitution itself was being debated, that's again historical fact. What happened in the Constituent Assembly, who said what, may not be relevant, but ultimately the decision of the Constituent Assembly was this, that they to have Article 370 for state of Jammu and Kashmir. To me, this decision appears to be the most significant and important because it answers several other questions. Why for Jammu and Kashmir? Why can't we remove it today in 2023? What is so great about Jammu and Kashmir? If it is a part of India, why should it have a separate constitution? Why should it have a separate flag? Why should the President of India have to concur or consult in the matter of application of laws? These questions are answered by the Constituent Assembly itself, by the debates of the Constituent Assembly itself, and by the very existence of Article 370 as well as very existence of the Constitution of Jammu and Kashmir. Now, this is a fact of history. None of us can alter this fact of history. That is, in my opinion, the premises of this case. And as we proceed further, we find that this basic premise has continued over the years. Now, it's a separate question whether it can be done away with. And if so, in what method, by what procedures, by what process? That's a separate question altogether. The first is, as I would submit for Lord's consideration, this fundamental premise that the state of Jammu and Kashmir was different, Union of India was different. They agreed to join hands, but on certain conditions, which conditions came to be incorporated in terms of initial instrument accession, set later on by the Constitution of Jammu and Kashmir, as well as by the Constitution of India. Now, well, there was a other factor, that was the matter went to United Nations and resolutions were passed. Those are also parts of your lordship's Constitutional Assembly debates. Well, these matters were pending. The issue is this, that state of Jammu and Kashmir and Union of India agree so far as the integration. When I'm using this word integration, I mean in the sense of Article 1 of the Constitution of India, as well as Section 3 of the state of Jammu and Kashmir. While that stays, but I, the state of Jammu and Kashmir, should have the power to regulate my own affairs. Accept what I have given to you. This is what I'm conditioned to that. So in instrument of taxation, I gave you something. I gave you defense, foreign affairs, and communication. I gave it to you, make laws for it. But for remaining, I will make my own laws. Now, this was the position in 1950. If I put it differently, I had the ocean of, now later on today we call it now constitutional autonomy. Ocean of autonomy available to me in 1950. This is also a fact of history and an important premise in this case, that this position is accepted both by the Union of India as well as by the people of Jammu and Kashmir. I would also like to say something.
I just wanted to point out, look, we have referred to the history, we have looked at the
I was
content
saying
points.
the premises only.
But the fact of the matter is, ultimately, when the constitutional document is drafted and adopted and applied by the people of India, and we, the people of India, include the people of J&K, they're not separate from them.
Yes.
We are part, they will be obviously in people of India, there'll be people from Punjab, there'll be people from Gujarat, there'll be people from J&K. Now, the only issue that may not really be, because we have moved with the passage of time, we have to move with the passage of time.
We have moved. That's what I'm saying.
We
I'm
have
coming to
moved.
that. Yes, I understand.
And
My
now
lord's
the
anxiety,
question today is,
whether-
really speaking, is the second part, which is Article 370, which is the main constitutional challenge before us. So let's confine ourselves to that.
It's a question of how the court is viewing the matter. Firstly, we are viewing the matter in a historical perspective, which becomes the foundation of this relationship between union and the state. Well, later on, over these 69 years, have this relationship moved closer? Has this relationship moved forward? And whether there is any possibility in 2019 that we could have done away with the relationship in a sense that Article 370 would go, Constitutional Jammu and Kashmir would go. Have we reached that stage or not? That I will indicate a lot.
We'll continue after lunch, but at lunchtime, the remaining council may please ration out time so that we are done by 4 o'clock this evening. No further now rejoinders, please. कर देना
Check, mic check.
Mr. Zafar Shah suggests that if you can formulate your points now that we are in the rejoinder, so that the others also have a look in.
Point number one, Milord.
Yes.
Is-
My notes of your submissions this morning end with an ocean of autonomy, which I found very interesting a phrase. So I put it into inverted commas.
Milord, my first proposition for the Lord's consideration is this, which I said earlier also, and somehow there were different views on that. That's after the execution instrument of accession. Where did the sovereignty go? That's a very important point we want to make.
Yes.
Where did the sovereignty go?
So how will you formulate it actually?
Yes, that's what's one of the issues involved in this case, because respondents.
So we'll say
argument
that
is
the
different.
instrument of accession did not result in a loss of sovereignty for whatever reason. Now, what are those reasons? Let's just formulate them.
I'm not going to the reason. I will only cite the judgment of this court.
All right.
That's, Milord's AIR 1962 Supreme Court 1288.
AIR?
AIR 1962 Supreme Court 1288. That is Prem Kumar Deb's case. There's also in the Your Lordship's documentation, rather in this case of compilation. Right. Volume 6, I'm told,
Page?
number 10.
Volume 6 page?
Pages. Page 135.
135.
Yes.
This
Just
is
have a
the
look
case
at it.
dealing with the constitution of the Union Territory Cadre for Honor.
Yeah, there was some grant or something. What is important is that they go into this question when only instrument of accession is executed. That's all. No merger agreement, no supplementary agreement, nothing of that sort. What is its legal status? They categorically rule that the sovereignty will continue to vest in the ruler. This is what is in this judgment. Paragraph 11 of the judgment, well, also we see that. Paragraph 11 of the judgment. I'll have read it, but I don't want to waste time. Because
Yes, you have read
I'm
it
told
already.
by my colleagues.
Yes, yes.
There's 11 expressly rules that. So on that basis, I'm saying, because earlier my lord's views were slightly different, particularly Justice Khanna's views were different. So I'm just citing the judgment, the constitutional bench decision, saying that the
You said 135.
paragraph 11,
PDF page 135.
PDF is what?
Which volume?
135.
Volume 6 said.
Volume 6.
Volume 6. Okay, I did volume 11.
Shah, these are
No,
just
not PDF,
questions
just
and queries. These are just questions and queries, just like you, this side, other side. These are just questions and queries, that's all.
No, my lord's asking me the question. I was just trying to respond to that. So my first proposition was that Maharaja retained his sovereignty. That's all I'm saying. Now, I also use the word, he retained residual sovereignty, if you lordship may recall.
Yes.
So residual sovereignty remained with him. Then what happened? After it was retained by the Maharaja, later on, at what stage it got transferred over to the people? It did not go into Article 1. It did not go into Article 370. That's what I'm trying to say. It has gone to the people. And it is in exercise of that residual sovereignty that the Constitution of Jammu and Kashmir was made. This is what I'm trying to say. It's incidentally meeting arguments of the respondents also that it was a concession, it was with our permission, so on and so
To
forth.
that extent, you're taking a different projection from others. There's a different argument as what was argued by Mr. Sibal and others.
No, but all the question of sovereignty we are, I don't think there should be much. And it begins with the expression, we the people of state of Jammu and Kashmir. That should be enough to indicate that it is by itself an independent, separate constitution. But to say that this is inferior, to say it is subordinate right is something unpalatable to us, that we feel that this is our constitution, like people of India would feel proud that they have a constitution, which though in our case, we had proper elections. And then only we had representatives who made this constitution, unlike the Constitution of India, which was, no elections took place for forming Constituent Assembly. They were the representatives of various provinces. So we're on a better footing. Now, this constitution which we made for ourselves, what did it do? In section 3, it said, now we are calling our constitution section, whereas that of Indian constitution as articles. This is also another thing which has slipped into our language. Actually, my constitution also has articles. This section 3, my lords, straightway stated that it shall be an integral part. That's the same position as taken in Article 1R instrument of extraction. That's there. But what's important is that when it says we will redefine our constitutional relationship, which was read in the morning, it is in the preamble itself. Now, what would exactly mean redefining constitutional relationships? What was the earlier constitutional relationship which we had, and it had to be redefined. It had to be enlarged or reduced or whatever was to be done. So we have two different entities, the Union of India and a federating unit. Between them, this was the mechanism in terms of which they would redefine their constitutional relationship from time to time.
Not redefined, further.
Further define constitutional relationship.
Yes.
This has happened from time to time. That's why the CEOs explain that from time to time, there was further defining of the constitution. Prior to that, what we had was only instrument of accession, and then 1950 order, then 52 order, then ultimately they got merged in 1954 order. Subsequent COs are all amendments made in 54 order. They are not independent by themselves. Why it was so? Because 54 order had been initiated by the Constituent Assembly itself. One of the issues which Mr. Subramanian also pointed out, I have a judgment, division by judgment of the High Court of Jammu and Kashmir, where they have gone into this question that it was initiated by the Constituent Assembly itself. That you also will see. This is in AIR 1971, Jammu and Kashmir, page 120. Justice First Lady has gone into this question. I will just read it quickly because we didn't have time to add to your lordship, so I'll just read it. So I read it for lordship convenience. Lordship may not have a copy of it.
Yes.
It simply says, I, Yura, do hereby direct as follows: a Constituent Assembly consisting of representatives of the people elected on the basis of adult franchise shall be constituted forthwith for the purpose of framing a constitution for the Jammu and Kashmir. This was published in Government Gazette on 1st of May 1951. In obedience, this is court finding. In obedience to this proclamation, a Constituent Assembly was convened for the first time on 5th November 1951, as mentioned by petitioner para 13 of the amended petition. On 15th February 1954, the Constituent Assembly passed a resolution adopting the report of the drafting committee and the annexure thereto, and thus by doing so, the Assembly gave its concurrence to the application of certain provisions of the Constitution of India to the state in the manner indicated in the annexure. The resolution of the Constituent Assembly may be quoted thus. Then they quote that following Government of India. Now, this only leads to the conclusion that the process was initiated by the Constituent Assembly itself, forwarded to the Government of India. The President accepted this, and then 1954 extension order was passed. This gives the source, the history as to how this 54 order has come into existence.
Yeah.
After this comes into existence, then follow the later on, as many as in all, 54 constitution application orders have been passed. Out of them, this one is by the Constituent Assembly. Remaining others are by the government of the state. And those are in the nature of amending this constitution application order of 1954. Because they could not do it otherwise. This is another aspect you also need to consider. This was approved by Constituent Assembly. Others were not. So what they did was, all these years, they have been amending that particular order. Now, sir, as a result of these constitution application orders, What happens is that which Lordship found interesting, ocean of my constitutional autonomy was reduced to a pond by 4th of August 2019. Whatever it was, what was just a call, it's a skeleton, I would not like to call it, but we still had. Now, what was that fundamentally I had on that date? Broadly, I have given that in writing also, broadly. I had my own permanent residence was one. I had the jobs reserved for the people who are permanent residents to only in the state government services. Number three, nobody could acquire the land. These were three fundamental things which I had as on that date. Then, of course, we consider it to be our identity. This 370 was in the nature of the identity of the people of state of Jammu and Kashmir, culturally and otherwise also. Linguistically also, different languages were spoken in Ladakh, Ladakhi, in Jammu, Dogra, in Kashmir, Kashmiri. So over these 70 years, a certain kind of interaction, mixing up of these languages, cultures had taken place, and it had evolved itself into a certain kind of a culture, which is a complete harmonious relationship between these three regions. This was the effect from time to time, and nobody questioned these CEOs also for all these years, that why are you shrinking our constitutional autonomy? And I had raised an argument last time also. I said that by conceding that the Parliament of India will have power of legislation over me, I was indirectly reducing the power of my own legislature, which otherwise it had. Name any act. I gave an example, they had also TAD Act. My own legislature could have made it. But then this state cabinet recommended through the governor, you apply 97 in a specified manner, and we had Indian TAD Act applicable to us. Of course, that's the fate of the history as it is. But whatever was left, it was there as on 4th. Now, when you take this decision, what is to be done on now 4th? Somebody took the decision that we want to get rid of it. Why should we get rid of it? That I still don't understand. Why can't the Union of India accept there can be two constitutions? Why can't Union of India accept that it's a kind of a federation in which there can be two constitutions? There are examples all over the world where there can be two constitutions. It is not this solitary case in the world. Why can't that fact be accepted? Third, when you accept that you are an integral part of it, yet you have this constitutional autonomy between total integration, total merger, and some space between the state and them for historical reasons, not of its own, for historical reasons. That's an important part of it. So therefore, there were some problems, some circumstances, rightly said by respondents themselves, there were circumstances, situations in which it was felt by whom? By both the leaders of Union of India as well as the leaders of Jammu and Kashmir to provide this space for this autonomy to the people of the state. We're not going to the why this autonomy was given, but the fact of the constitutional position that this autonomy was given to us. And this autonomy could be taken, as all the councils have correctly stated, by concurrence, by consultation. You could take it away from us. We had to concede. We were on the giving side because it was with us. We had to donate. We had to surrender our power. The Union of India had not to do anything. It had promised only what was in the constitution. List 2 would apply to you, that is all. There was a promise not specially to states of Jammu and Kashmir, but all the states in India. That is how the constitution was framed. But so far as our constitution is concerned, we had to donate from time to time this power to Union of India. So both had to agree. Now take a look at 370 by and large. I'm not reading because time is less. Because 370 talked of three things. One, you need consultation, concurrence, and recommendation. Three words are used. This is one side. Two, who are the institutions involved? You have the President of India, you have the government of the state, and Constituent Assembly. Three. All the provisions will also, which only three authorities are involved. But this government of the state is further requiring, in terms of the explanation, that it means a person who is recognized President of India, who has aid and advice of the Council of India. I lay emphasis on this, that this is a mandatory, indispensable part of Article 370 that you have to have in all situations. 356 or no 356, you need to have aid and advice of the Council of Ministers. You cannot make any CEO without the consultation, without the concurrence of the council of ministers. I'm laying emphasis on that part. Yes, sometime back there have been out of 54 constitutional application orders, there were about 6 of them which were passed when state was under governor's rule or president's rule. But our stand on that, they were questioned. Before this court, I am told that some writ petition is pending. They were questioned, Jammu Kashmir High Court, the things remain. People did question them. Of course, they did not reach the logical conclusions. But at the same time, I must say that if they are unconstitutional, they can be questioned at any point of time. Law of laches does not apply to when the statute is unconstitutional or any action is unconstitutional. So even today, when we see this constitutional application of 2019, and we are questioning that, so we are free to question that on the basis that it was done without Council of Ministers being in place. This is the crux of our argument in this case. That's why I said earlier that let us go to the fundamentals. That the fundamentals in this case are this: number one, that for this kind of change, which was made, it is not relatable instrument of accession, therefore consultation was not required. Concurrence was required. It is a mandatory requirement of 370, number one. Number two, the definition of the government given only for purposes of 370. I must make little digression here. We have government of the state under the Constitution of Jammu Kashmir. And we have a far better provision there. That is section 35, which says, sir, that the governor will act only, the word used is only, on the advice of the Council of Ministers, which was not, you also will not find it in the Constitution of India at all. That way, how better our Constitution is. What your lordship is ruled by judicial decision, that the advice of the Council of Ministers is binding on the president. Our Constitution already way back in 1957 contained this provision that it should only act on the aid and advice of the Council of Ministers. Now, what do? So it means that the governor could not act without aid and advice of Council of Ministers in our Constitution. And here in this case, the governor acts. Fundamentally, apart from the other jurisprudential basis of the submission which have been made very at a different level, fundamentally, could they do that? Could the governor at that point of time do that? Now see more additional reasons. At that point of time, I was under 356 President's rule. What is its effect? Leave the 356, or what does it contain 357? My legislature is not my own, it is taken over by Parliament. My governor is not my own, his powers are taken over by the President. My government of the state is not my own, it is taken over by the President. All this is taken over by the President. Then in terms of 370, who gives concurrence? And who accepts that concurrence? We have a judgment of this court saying that when 356 is there, the powers are taken over by the President. How does he act? The President will act on the basis of the advice of the Council of Ministers, and this Council of Ministers is like the cabinet of the state government. If this be the correct legal position, it all means all is rolled into one, that is President of India. So it violates on the face of it the text, the requirement of Article 370. Forget for the time being, of course, without prejudice to what brilliant arguments have already been made, without prejudice to them. How could the President of India, when 356 is in operation, act on the advice, on the recommendation made by Governor of Jammu and Kashmir, which governor had the status only, some, your lordship, some decision describe him as an agent of the President during 356, or some judgment to say that he acts as the President. In either of the situation, he is not the governor who has aid and advice. So for purpose of 370 and for purpose of other functions of the government, I respectfully submit there is a difference between the two. Specifically for 370, you need Council of Ministers. I'm not able to conceive of a situation where there cannot be Council of Ministers. That's the third thing. And the fourth thing, which is very important, is this, that you have applied 367 and modified it and applied it. Now, for the consideration of my Lord Justice Khanna in particular, My lords, have been observing. What do you think of 3(1)(d), where you apply constitutional provision with modifications and exceptions? I'm saying something else. You first applied 367 by virtue of 3(1)(d). You applied that to which provision? You applied that to subclause 3 of 370. Subclause 3 says, notwithstanding anything contained here and above. The question which immediately falls for consideration is, if you have carried out a modification in terms of 3(1)(d), but applied that modification to subclause 3, when the 3 says notwithstanding anything contained here and above, isn't that 367 modification excluded from application to subclause 3 of 370? I'll consider this aspect of the matter. And it says notwithstanding anything above would mean also any constitutional application order issued under 3(1)(d) will also not apply when you want to act under subclause 3 of 370. So therefore, on that basis also it has to be faulted. So therefore, I'm submitting is going by the basic premise, the basic principles, that this action of 272, it does two things. Best part, then the last thing which I want to submit to Lordship consideration is one more thing. This power of concurrence. I say, for your Lordship's consideration once again, in 1957, we adopted our own constitution. Prior to that, we had Constituent Assembly. As rightly said, Constituent Assembly can do, undo things because it is not subject to any fetter. There is no control on a Constituent Assembly because it's free to evolve and deal with its affairs. But after the Constitution was adopted on 17 November 1956, I'm submitting this. The state government comes into existence under the Constitution of Jammu and Kashmir. But at the same time, the state government is required to give its concurrence or consent under 370. I say my constitution, Jammu and Kashmir constitution, is in the nature of a limitation on the power to give concurrence after 1957. Meaning thereby, even if there was Council of Ministers in place as on today, they also could not give any concurrence because it is subject to the limitations of the Constitution of Jammu and Kashmir. Now, what are those limitations? On the prima facie, I will show. If you will have a look at 272. The first part says, the Constitution of India as amended from time to time shall apply, subject to the modification as follows, that is 367. Means the entire Constitution is made applicable on the so-called invalid unconstitutional concurrence of the governor. When you do that, you are contradicting Constitution of the state. And when you are contradicting Constitution of the state, there is a limitation in your power of giving concurrence under the Constitution of the state. Meaning thereby further, that our Constitution had to stay. It had to permanently stay because the state government no longer could give its concurrence in contravention of the provisions of the Constitution of the state. That limitation will have to be read into this power of concurrence after 57. Of course, there will be provisions which don't come into conflict. For example, take the High Court. Somebody cites the example of the High Court. Now it is established under my Constitution. When you say somebody gives concurrence, the Article 215 of the Constitution of India will apply. It comes directly to conflict with my Constitution. The question is not that that is superior, I am inferior. No, the question is, did I have the power to give the concurrence for the application of 215 or any other provision of the Constitution of India? My submitted lordship is, I am controlled in my concurrences now. I am controlled in my consultation is something different that relates to instrument of accession. But in respect of application of these constitutional application order, I am controlled today by the Constitution of Jammu and Kashmir. So therefore, on that second ground, also, I say that this 272 as well as 273 are both are constitutionally absolutely invalid. Now, my lords, observe that, okay, you are still in history, let us progress further. Isn't this COs issued 54 in number from time to time? Isn't no, it was not a step in right direction. I put it to myself. It was getting closer and closer. What made you to do it on 5th August? It is not still forthcoming. And there is something more to it also. You also may recall, I said, when this concurrence is given by the government, this Governor Jammu and Kashmir as stated in the text of 272 order. When was that concurrence given? Who gave that concurrence? What was the nature of concurrence? No material that is concealed from this court. No material is produced before the court. It is not in their affidavits. Despite having been stated in the petition that, look here, we want to know who gave this concurrence. What is the date of that concurrence? Who signed that concurrence? Was it done 1 day before? Was it done 10 years before? Who gave that concurrence? We are entitled to know it. This court is entitled to know it. There is no material on that basis. So therefore, that apart. But further than somebody says that we have given the concurrence, it doesn't look legitimate. It doesn't look sustainable. It looks all against the Constitution itself. Then lastly, I would like to submit, many statements were made here. Insofar as the development is concerned, I have only one thing to say to our learned friend, Solicitor General of India. They say self-governance is better than good governance. That's all I can tell him. Give us our self-governance back. That's number one. Number two, somebody also said it here, it's very important. Nation has to grow. We can't waste our time. We want to have a unified nation. Of course, very noble thought, very good thought. But then for that, you have to win over the hearts of the people. You cannot form a nation by force, by compulsion. Win the hearts of the people. If your lordship decided this matter in favor of the petitioners, your lordship will be going a long way in winning over the hearts of the people of Jammu and Kashmir. That's all I would thank.
Thank you, Mr. Akshay. Dr. Bennett?
Just a minute. Just a minute. Just last thing, Milord, only last say that. What initially we were promised, I just look at it from another perspective, and the people who like to know that. What initially was promised was we'll put in short accession to a referendum. It was not done. They told us, not people of Jammu and Kashmir. It was Governor General's letter. They took the matter to United Nations. They said, go for plebiscite. It is not done. Now, after that, this constitutional autonomy was left all these years. But in 2019, even that is also taken away. Who has lived up to his commitment? The great leaders of India, Jawaharlal Nehru and Patel, they were statesmen. They were not politicians. They made these commitments to the people of the state of Jammu and Kashmir. It is in parliamentary debates. It is outside the parliament. It is everywhere. But now today, since there are no statesmen left, we have politicians. Decisions have been taken. People feel betrayed. That's all I can say. Thank you.
Yes, Doctor.
Lord, I have 5 arguments. That's just right way away. He sent messages from me. Go ahead of me. Somebody.
May it please. My Lord, I have 5 submissions to make. The first relates to the temporality of Article 370 and its interpretation. And how it impacts on CO 272 and 273. My second related proposition is that mandatory provisions of the Constitution are not defeasible and cannot be derogated from. The third is, my Lord, the basic structure argument, which has 2 aspects, my Lord. Firstly, basic structure is a constitutional limitation. This is not the argument we wish to advance. That is, if there is an amendment, basic structure will apply. That's the constitutional limitation. What we emphasize is basic structure as a principle to be applied by all authorities and especially the courts. The fourth, my Lord, argument is the location of sovereignty and the constituent power.
Location of sovereignty in the constituent power.
No, my Lord, the location of the substitution of a statehood, my Lord.
Sorry, the fourth one.
Sorry, my Lord.
How did you begin the fourth proposition? I perhaps didn't take it correctly.
The sovereignty proposition, my Lord.
Yes, how do you begin? Did you say location of sovereignty or?
My Lord, I'll explain that when I come.
No, but just as a head, what would you like us to say?
Broadly speaking, my Lord, the argument is this, that generic basic sovereignty lies with the people. To operate this, there is sovereignty which is external in nature in terms of international law. That is, no other state can make you a vassal state or have any power over you. And the third, my Lord, is after the Constitution has been enacted, where does the constituent power lie? On which Mr. Dwivedi had a few things to say. And the fifth argument, my Lord, is the substitution of statehood by union territory, on which I want to cite just one section of the Reorganization Act. What I propose to do, my Lord, is this, that as far as the citations I want to give, I put them on a piece of paper. I think they've been uploaded. I'll hand it over to your lordships, so that your lordships doesn't have to scribble. I think you've done enough scribbling for quite some time. So, my Lord, let's come to the first question of temporality. We've done our share of scribbling too, my Lord. Let's come to the question of temporality, because that goes to the real issue before your court, lordship's court. What does temporary mean in 370? The Chief Justice pointed out that when you contrast it with 269, where it says 5 years, therefore certain conditionalities have to be met. If those conditionalities are met, then at that particular point in time, the temporariness goes. Now, what were the conditionalities, my lord, that were available as far as 370 is concerned? There were two sets of powers in 370, which were assigned to the Constituent Assembly. The first power was to reject the constitution-making process completely. That is 370 subclause 3. This is a power that the Constituent Assembly did not exercise. CO 44. CO 44, my lord, where this power was used, it did not exercise this power to abrogate the constitution process completely. The second, my lord, conditionality was to fulfill its task of making a constitution. This task was fulfilled in 1956 and came into effect on the 26th of January, 1957. So both temporalities, my lord, exhausted themselves in 1957. After that, my lord, 370 ceases to be a temporary provision. I'm not saying cease, which has been argued on this side by one council, that it ceases to exist. I'm saying it ceases to be a temporary provision. In my respectful submission, what follows is that it becomes a special provision of the Constitution, like 371A, all the schedules, etc. So 370 would be read, my lord, as a special provision, just like the other special provisions that you find in 371A onwards. Or the many provisions that you find giving autonomy in the 6th schedule, which is such a vast schedule of autonomy, because by this time, autonomy was attained by the JK Constitution. Now, my lord, there was what kind of federalism is this, my lord? It's an example of cooperative federalism. Where two powerful democratic forces meet and decide on the fate of a particular area of the Constitution. One powerful democratic force came from the people of Jammu and Kashmir themselves in the antecedent discussions, as well as through the Constituent Assembly. That is, a powerful democratic movement had to be taken into account. The second, my lord, is democracy had to be preserved as part of cooperative federalism. Hence, to make it a balanced cooperative federalism, we find the words concurrence, consultation, recommend. These are methods of cooperation in a cooperative federalism. And they're writ large in the 6th schedule as well, my lord. I've taken your lordship through that. I won't do it again. Now, my lord, the argument on the other side is that it remained temporary for 60 odd years. Lord, that's the argument is almost a farce. If a constitution has continued for such a long period of time and been used as such for a long period of time, you can't say it remains a temporary provision. What is left of 370 is just 370 subclause 1. Because 370 subclause 2 and subclause 3 are dependent on interaction with the Constituent Assembly. This is a mandatory provision which is indefeasible. Therefore, my lord, when I say a special provision survives, my lord, in the spirit of cooperative federalism, it is 370 subclause 1. The rest, my lord, because the Constituent Assembly has completed both its tasks or conditionalities, one in not going the non-constitutional route or going the constitutional route as the case may be, nothing survives in 370 subclause 2 and 3. Nor is it possible in 370 subclause 3 to argue a doctrine of substitutability. That for Constituent Assembly, you can substitute legislature. Nor, and on that I'll give a note on what the proviso says, my lord. The proviso, my lord, has a symbiotic relationship with the main provision of 270 subclause 3. Now, some arguments were made, my lord, and I must, because I don't know whether they were made frivolously, that 370 is a compromise. If, my lord, 370 is a compromise, you'll find compromises right throughout the Constitution. Take, for example, Article 25. Sikhs are allowed to carry their daggers. You want to get rid of that, my lord? You have to have a constitutional amendment. This is a compromise. The entire 6th schedule is a compromise. But the most important compromise of all concerned the Privy Purses. It's a compromise between 271 and 362. They said, all right, you've surrendered everything. By way of compromise, we give you a Privy Purse. And what do the two judgments, my lord, on these two say? Madhav Rao Scindia is clear, along with the other judgment, to say, if you want to take this compromise away, then you must amend the Constitution. Therefore, any compromises that are there in the Constitution, my lord, follows from a very important insight, my lord, of Fali Nariman's, that if today we were asked to make a constitution, we would not succeed. It's in one book of mine published 2 years ago, but that's a different matter. Israel was never able to come to terms with getting constitution through because it could not evolve a compromise anywhere. New Zealand did not initially have a constitution of its own. It couldn't come to terms. So as far as compromises are concerned, they are writ large across. That is the process of constitution making, to accommodate the largest number of views and come to a compromise. And that is borne out, my lord, by the princely persons cases. That was a compromise. We'll give you your princely purse. And when they tried to change it by definition, Madhav Rao Scindia, the first Madhav Rao Scindia, my lord, said, sorry, by definition, you cannot change it. This is, in fact, a compromise which is embedded in the Constitution 271 and 362. It is only after the amendment was made that the compromise was set aside as a part of the constituent power. Now, my lord, I want to test this particular argument. One argument has been made, my lord, with the second argument that I want to advance is non-derogability of mandatory provisions. And then we will test this against 272 and 273. There is no doctrine of necessity in our constitution, Manoj. There is a doctrine of constitutionality, but no independent doctrine of necessity. It is about the most dangerous addition that one can make to any constitutional process, where you say, because of necessity, we could not follow your mandatory provisions. Your lordships have held that even directory provisions must be complied with to the extent possible, but we're not there now. We're on the question of mandatory provisions. Now, as far as 272 and 273 are concerned, my lord, one argument that I want to enlarge on the basis of what Mr. Gopal Subramanian said, my lord, kindly have a look at 152. This, I won't give the dates again because these dates have been given by Mr. Subramanian. In this part, unless the context otherwise requires, the expression state does not include the state of Jammu and Kashmir. Therefore, as far as the entire part is concerned, this constitution recognized the relevant provisions relating to the states, legislature and otherwise, my lord, and incorporated those provisions after, my lord, 238, etc., was done away with, as my lord, the Chief Justice pointed out. Otherwise, there would have been a vacuum. How was that vacuum filled? By reference to the JK Constitution and those relevant parts of the JK Constitution itself. Then, my lord, if your lordships will kindly come to 308. My lord, is part 14 of the Constitution, which deals with services under the Union and states. All this, of course, has been done away with, my lord, now, without amendment by the Reorganization Act. It says in this part, unless the context otherwise requires, the expression state does not include the state of Jammu and Kashmir. This, my lord, would be a vacuum, but for the fact that the constitution makers were aware that provisions relating to these two parts relating to 152 and 308, were already there in the Jammu and Kashmir Constitution, and in fact, as far as these are concerned, they were incorporated by implication into the Indian Constitution. Now, my lord, on the basis of this, let us just test 272 and 273. My lord, there's another aspect, my lord, and our small argument was made that the preamble doesn't contain socialism and secularism. It's actually there in the Jammu and Kashmir Constitution. I'll just give your lordships the sections. No, just give me my black volume. First, my lord, kindly come to section 13. This is volume 2, PDF 20. I'll just read it out, my lord. There's no point, your lordship, Otherwise, I'll dream of PDFs all my life, my lord. I don't want to do that. Now, my lord, 13 says, state to establish a socialist order of society for the promotion and welfare of the people. Long before it came into the Indian Constitution, what was the necessity of amending the preamble? Then, my lord, if your lordships would kindly come to section 20, compulsory education. The JK Constitution says compulsory education in certain cases and reflects those educational provisions in the directive principles. And the third, my lord, is section 25, the state's duty of the state to foster equality and secularism. So it was no great omission, my lord, as far as the JK Constitution was concerned, as has been pointed out. Now, my lord, let us come to (272) and 273. Bearing in mind that mandatory provisions of the Constitution are not defeasible. My second proposition. Now, my lord, one thing that I forgot to mention when I mentioned 152 and 309 of the Constitution that says it shall not apply to Jammu and Kashmir is it was done by this amendment of the Constitution in the 7th Amendment. Therefore, if any change had to be made, it could only have been done by the constitutional amendment and not otherwise. With this, let me read, my lord, CO 273 first. None of the conditionalities of 3C70 and subclause 1 are met here. It says in exercise of the powers of clause 3 of the President of India on the recommendation of Parliament. Where does Parliament come in, my lord? The body in question, according to the original Constitution, is Constituent Assembly, and according to 272 is the Legislative Assembly. Where is the question of Parliament coming in as a double substitution, which is there in 272 and 273? But let me just read on. All provisions of the Constitution, as amended from time to time, without modification or exception, shall apply to the Jammu, notwithstanding anything contrary to Article 152 and 308. Those are the provisions, my lord, where the Constitution, 7th Amendment said that these provisions will not apply to Jammu and Kashmir. Is it possible, my lord, within an exercise of power under 370 to amend provisions of the Constitution or not? Because this was the stumbling block, my lord, in their way. The answer is they have not, my lord. Of course, as far as the conditionalities are concerned, none of them are met. There is neither concurrence, nor consultation, nor recommendation. It just says on the recommendation of Parliament. Where does Parliament come into this? Therefore, my lord, 273 is an amending provision well beyond the scope of Article 370. And not only is it amending, my lord, it also goes further to destroy any other article of the Constitution or any provision of the Constitution of Jammu and Kashmir, any law, document, judgment, ordinance, order by law, rule, regulation, notification, custom, usage, having the force of law in the territory or any other instrument. Well, this is an amendment and actually an abrogation of 370 itself. That power having gone, if we agree that 373 has gone because the Constituent Assembly cannot be substituted. So the argument that Mr. Sibal made and was just made by Mr. Zafar Shah is there are two entities here. Two entities who are part of cooperative federalism. They have to interact. And the interaction is there in Article 370 and is entirely and totally missing from 273. If 273 falls, my lord, there will be a revival of 152 and 308. There has to be, because they are not, you cannot amend the Constitution which has actually been amended by the 7th Amendment. Now let's come to 272. This begins, my lord, by saying, in the exercise of power under clause 1, bear in mind, my lord, the exercise in 273 is under 373, which in our view has actually disappeared. Now I'm going to show its reappearance in another form. In exercise of the powers under clause 1 of 370, the President, with the concurrence of the government of Jammu and Kashmir, is pleased to admit. Now, my lord, if your lordship were to see the main provision of 367, subclause C says, references to the government of the state shall be constituted as including references to the governor of Jammu and Kashmir acting on the advice of the Council of Ministers. Therefore, my lord, when they say in concurrence with the government of the state, it has to be on the basis of the advice of the Council of Ministers. Therefore, there is a contradiction here between the interpretation clause and the opening clause of 272. This too is draconian because all the provisions, my lord, which are relatable, it just wipes them out completely without following any mandatory procedure. Now, what is the saving grace, my lord, that is provided here? And that is indeed, in the proviso of clause 3, Article 70 of the Constitution, the expression Constituent Assembly referred to in clause 2 shall be read as Legislative Assembly. Here there is a double substitution according to them. Firstly, the Constituent Assembly is replaced by the Legislative Assembly. They're not on par, my lord. They're simply not on par. The Legislative Assembly, this idea that both had legislative and concurrent powers, constitutive powers, that is true of the Constituent Assembly of the Indian Constitution. There's a whole set of debates dealing with the legislative powers. As also, my lord, of the Jammu and Kashmir Constitution. So can such a substitution take place? Now comes the double substitution which we see in 273. Instead of the Legislative Assembly of the state, we get Parliament. So these provisions now involve a double substitution contrary to 373, contrary to 272, and we now move from the provisions, my lord, of recommendation under 370, concurrence, which is of course completely missing, my lord. Mr. Zafar Shah has pointed this out. I don't want to elaborate it. Totally and completely missing. The arena of cooperative federalism is entirely and totally missing. But can you have a double constitution substitution in this way, my lord? And that is to say that 367, the added clause is that the references to the government of the state shall be construed as references including the governor of Jammu and Kashmir acting on the advice of the Council of Ministers. This is what the new interpretation is. You didn't act on the advice of anybody. You just said here that concurrence of the government of the state. Now, according to 367 itself, it means with the Council of Ministers. That is a mandatory provision. So, my lord, 272 and 273 are overbroad in violation of mandatory provisions of the Constitution. And shift the entire concurrence or consultation provisions or recommendation provisions from the authorities of Jammu and Kashmir to Parliament. This is the double substitution argument that they have advanced. Now, my lord, we come to the interesting part, my lord, of Article 3. Article 3 has a mandatory provision. I put that in my original submission, my lord, from 1960 onwards, that you must circulate any bill or change, now the reorganization of, you must circulate it to that legislature. This is a mandatory provision. It is true that your lordships have also held, and those references are there in my original submission, that the centre is not bound by all your recommendations and subsequent changes can take place. But this does not take away from the fact that Article 3 is a mandatory provision. Now they say, as far as this is concerned, under Article 356, there is a power, my lord, to make incidental provisions that are necessary and desirable. And they say that one of the provisions that was made was that Article 3 will not apply. That is in not the President Proclamation of 19th December. Effectively, that's what it says. These provisions will not apply. It can't be done, my lord. President's rule, under President's rule, you do not have the power to do away with a mandatory provision of the Constitution. Now, my lords, I want to point out one thing, my lord, to your lordships, if I may. About the Reorganization Act, my lord. I just want to read one provision to your lordships, my lord. And that is Section 73. This is, my lord, Volume 3, PDF 112 at 130. I'll read it out, my lord.
Just repeat that, Mr. Now.
Volume 3, 12 and 130.
Volume 3, PDF 112, where it starts, my lord.
Documents, why?
The Reorganization Act. And I'm reading Section 73, which is at PDF 130. If the President, on a receipt from the Lieutenant Governor of the Union Territory of Jammu and Kashmir or otherwise, is satisfied that a situation has arisen in which the administration of the Union territory cannot be carried out in accordance with the provisions of the Constitution. That is the same as 356. Now look at the next clause. That for the proper administration of Union territory of Jammu and Kashmir, it is necessary or expedient to do so. This is also, my lord, there in Article 239A B. So we've added one more section to it, that if you think it is not expedient, the president may suspend all operations. The more important thing in section 73 is it has no time clause. So today, my lord, when your lordship asks for a roadmap, today the Constitution, my lord, that the president's rule that survives is under section 73. Unlimited time when it is expedient and necessary to do so. Necessary or expedient to do so. Lord, this is the core of the problem when your lordship asks for a roadmap. They are unable to give one. They too are, in a sense, are arguing that the Reorganization Act is in fact transitional in nature. A time will come when statehood will be restored. This is no roadmap at all, my lord. It is entirely and totally illusory. What is not illusory is the continuance of president's rule under section 73. This goes to the core of the governance, my lord, and the relationship of cooperative federalism. I want to make one more further point, my lord, on mandatory provisions. Although, my lord, there are several occasions when 370 has been used under president's rule, I'm going to make the broad argument, my lord, whether it was challenged or not is irrelevant, that when there is president's rule and cooperative federalism under Article 370 cannot apply, then 370 cannot be used at all. Because the mandatory provisions, my lord, require concurrence, consultation, recommendation. If these are absent and president rule, because of some suspensive order, gets rid of it, my lord, in no president's rule can we apply, my lord, 370. Because the very foundation of 370 would disappear by an exercise of a CO. So these are my first two propositions, my lord. Now I go to the third one. I'll have something to say in the proviso, my lord. What I've done is I've called out the authorities that I want to rely on, which I'll hand over, rather than your lordships, my lord, be troubled. And that is, my lord, relates to the basic structure doctrine. It is not the case of anybody that the basic structure doctrine applies in this case as a constitutional limitation. Nobody has argued that, my lord, and it cannot be so. But what the basic structure doctrine has been applied as is as a principle of the Constitution. Now in Nagaraj, my lord, and I'll point out those two paragraphs. This is volume 19. PDF 164 at PDF 195. And kindly bear in mind, my lord, that in Bomai there was no constitutional amendment involved. And there are many provisions of that nature. There the principle, my lord, of the basic structure was applied. It is our respectful view that if democracy, federalism, reasonableness is given the go-by, then it would follow, my lord, the principles of these underlying these basic structure formulations will necessarily, my lord, guide your lordships in the exercise of any constitutional power. Now, my lord, I'm just going to read two passages from Nagaraj. I've given your lordships, my lord. The citation is 2006 8 SCC 212, which your lordships will find in volume 19, PDF 164 at 195. Has your lordship got that one? Para 24. The point which is important to be noted is that the principles of federalism, socialism, secularism, and kindly bear one more thing in mind, reasonableness and socialism are beyond the words of any particular provision. They are systematic and structural principles underlying and connecting various provisions of the Constitution. They give coherence to the Constitution. They make the Constitution an organic whole. They are part of the constitutional law, even if they are not expressly stated in the form of rules. Now, in Nagaraj, they defended the constitutional amendments, but subject to certain conditionalities that were imposed. And they said the identity of equality is not taken away, but you will follow these guidelines. Now, my lord, kindly come to the bottom of that page, that is para 26, next to placetum G. Overarching and informing of these rights and values is a principle of human dignity under German basic law. Similarly, secularism is a principle which is an overarching principle of several rights and values under the Indian Constitution. Therefore, axioms like secularism, democracy, reasonableness has been elevated to a part of the basic structure. Apply that to 272 and 273, my lord, and the answer will become clear. Social justice are overarching principles which provide linking factors for the principle of fundamental rights. These principles are beyond the amending power. They pervade all enacting laws, and they stand at the pinnacle of the hierarchy of constitutional values. It is our case, my lord, that the basic structure applies not as a constitutional limitation, but as a set of overarching principles which are part of the Constitution. Now I get back to my argument, my lord. It is idle to say that when my lord the Chief Justice used the word asymmetric, it was used in any casual sense. That is NCT 2. I said that it is a multi-symmetrical constitution, which I've shown to your lordships. And there is a violation of the multi-symmetric provisions of the Constitution as far as this exercise of 272, 273, and 370 is concerned. Otherwise, my lord, the whole Constitution would become meaningless. Boma is a classic example, my lord, of where there is no amendment whatsoever, but you apply the principles. And there, of course, there are a host of others. Therefore, my respectful submission to your lordships, my lord, is basic structure as a statement of principle applies in this particular case, though not as a constitutional limitation. Because I'm equally allergic, my lord, to the idea of going beyond the amendment process as far as constitutional limitation is concerned. I'm allergic to that particular idea. Constitutional limitations have their limitations in 368, provided there is an amendment. But there are also principles that are violated, and to that they have not provided any answer. Now I'm on the question of sovereignty, my lord. Anything more to be said? Now, my lord, I come to the question of the location of sovereignty in the Indian Constitution. Now, my lord, sovereignty has one meaning in international law. That is, you are not under any other country. To that extent, my lord, there is, as my Lord Justice Khanna pointed out, across the board, nobody has argued that the Indian Constitution is not sovereign, and that Article 1 does not apply across the board. That is nobody's case. But I'd earlier made a distinction between external sovereignty
And internal sovereignty.
and, my lord, internal sovereignty. Now, I think internal sovereignty, my lord, is a bit of a misnomer. It really means the application of sovereignty in the distribution of powers. I'm amending that to that extent. Therefore, my lord, how is sovereignty to be exercised is what one means by internal sovereignty. It's the exercise of sovereignty distributed throughout the Constitution. Mr. Dwivedi has made some arguments, my lord, that there are many provisions of the Constitution that says this will not be an amendment to the Constitution. I've got, my lord, passages from Keshwanand. They were aware of these provisions, and they regarded this provision simply to mean you don't have to follow the procedure of 368 and nothing more than that. The constitutive power, sovereign power, exists in 368 and in no other provision of the Constitution. Otherwise, we'll be saying, my lord, that when the Constitution is, that you can amend the Constitution for the next 2 years, that during that interregnum, it's a constitutive power. And finally, my lord, I come to my last point, my lord, which is the substitution of statehood by union territory. My lord, the Constitution actually divides itself into two halves. A federation of states is one part of it. And the second part of it, my lord, are what could be called devolutionary provisions. That is union territories. Now, England, for example, my lord, Northern Ireland, my lord, has a lot to do with that since I taught there at Queen's, is a devolved provision. Wales is a devolution provision, so is Scotland. Whether they will be removed or not, my lord, is within the gift of the supreme power of Parliament. That is a different matter altogether. What has happened is that statehood has been taken away completely. Therefore, as part of the federation, union territories are not part of the federation of states. they are revolutionary units which can always be taken away. And that is a fundamental distinction, my lord, recognized in all constitutional jurisprudence between, my lord, a federation and a devolutionary power. Now, my lord, I'll just hand over that note to your lordships, if I may. I think it's been put up as well. Just give me one copy. So that your lordship doesn't have to take down references, etc. My lord, the first is in relation. Has it been handed over, my lord? I think it's been uploaded as well. Huh? As a note on rejoinder, my lord. On proviso, my lord, the classic description of a proviso was given by Justice Fazazali in Sundaram Pillai. We need not multiply authorities after authorities on this point.
That part, it's a classical judgment on, it's a classical judgment.
That's right, my lord, but what it says, it may entirely change the very intendment of the instance by insisting on certain mandatory conditions. In order to make it workable. Now this, my lord, Mr. Gopal Shankar Narayan tells me, has been approved in Manohar Lal's case. Your lordship may just note that, my lord. Constitution Bench 220, 8 SCC 129 at para 193. At para 193.
Read the citation, please.
Over the page, my lord, I won't take your lordship's. 2020 Constitution Bench. Your lordship is familiar with these provisions, my lord. That's why I don't want to read all of it. And over the page, my lord, I've given two further examples of the proviso as a condition precedent. That is, Edwinson, State of Assam, where consultations had to be taken with the board, or Narayan Das, my lord, where consultations had to be taken. And this is a condition precedent. Now I come to, my lord, on the application of the basic structure doctrine as a principle of interpretation of the Constitution. Bomai, my lord, is my first example. I've given your lordships the paragraphs and the PDFs. In Kolo, my lord, and across the board, use was made of basic structure as a set of principles. Once again, I've given that at 3.2. As regards interpreting 301 and 304 Jindal, the government of NCT versus Union of India, my lord, while interpreting the proviso to 239 AA4, and over the page I've reproduced from the second NCT judgment, my lord, because it's in my written submission, but I just reproduced that paragraph. I don't need to read it. These are all principles that have been applied across the board in interpreting statutes as well, and in certainly as far as constitutional provisions are concerned. Now, my lord, the argument that was advanced was that there are other provisions that by Mr. Rakesh Trivedi, which say this will not be deemed to be an amendment of the Constitution. In Keshwanand, my lord, the lordships were aware of this. For example, Justice Hegde and Mukherjee, amendments under 4(169), 7 of the 5th schedule, para 21 of the 6th schedule, need not comply in the form and manner prescribed under Article 368. So, my lord, it is not that they are a part of the constituent power. They need not comply with the provisions of 368. The same, my lord, is said for Justice Palekar, who once again notes these provisions. I won't read that, my lord, because the point is there. Then Justice Matthew, my lord, who says enactments under 4169, para 7, 5th schedule, para 21, are effected by ordinary lawmaking procedure, which is different from the procedure under Article 368. They're not they're not ancillary constitutional power. They are, in fact, special provisions which don't require the invocation of 368. And then, my lord, there is Justice Beg and Justice Chandrachud. My lord, that's all I have to say. My lord. Now, my lord, what is the reliefs that we are seeking? If we stay within, my lord, a very narrow circle, then Mr. Sibal is right. All your lordships have to adjudicate is the temporality of 370, 272, CO 272, 273, and whether mandatory provisions are defeasible. That is all that is before your lordships. The antecedent speeches, so many have been quoted, my lord, in the list of dates, are totally and completely irrelevant. Because as soon as 370 is born, that is the provision which is the incorporating provision, and there is no other. You don't even have to refer to Gopal Swami Iyengar's provisions.
Thank you, Mr. Lal.
I'm obliged.
Thank you, Dr. Lal.
May it please the Lord. Lord, whichever way your lordships were to look at this, Lord, democracy, federalism, rule of law, Lord, constitutionalism, each one of them is a basic structure of the Constitution as has been held by your lordships. Every one of those principles of Lord, basic structure are not completely thrown out of window by exercise of this power by the president. Now, Lord, there are three broad arguments which have been raised on behalf of the government of India. One, that Article 370 is temporary. Two, that presidential exercise under sub-article 3 of Article 370 is a valid exercise. And three, of course, that the state reorganization is a valid piece of legislation. Now, Lord, let me begin by, Lord, pointing out that, Lord, in Coelho, your lordships have expressly now said, Lord, para 137, just kindly make a note, I'm not going to trouble your lordships taking to the paragraphs. Para 137, Lord, quoting Sirvai, that there are two powers which are fiercely independent. One is the constituent power, which is a plenary power. The other is a power of amendment of the Constitution, which is a derivative power of the plenary power. So power of amendment is always not conferred by the constitutional framers, and that power must be exercised within the four corners of the Constitution. We have now a third situation where there is a constitutional power to be exercised by the President of India. Now, my Lord, first and foremost, as your lordships have brilliantly put it time and again, nobody is imperium in imperio under our Constitution. Lord Digvijay Mote is a judgment where your lordships very brilliantly, Lord, put this. 1993, 4 Supreme Court cases 175. 1993, 4 SCC 175. No one is an imperium in imperio in our constitutional order. It's reasonable to hold that the election commissioner cannot defy the law armed by Article 324. Now, can President defy Article 370 merely because he has power under 370, which he assumes to have the power? Now, my lord, second principle that your lordships have brilliantly put beyond pale of doubt is that there is no unreviewable decision under our constitutional order. Every decision is subject to judicial review. Nothing is unreviewable. Parliamentary laws are subject to review. Executive orders are subject to review. Constitutional exercises are subject to review. And that's not where this democracy survives. Now, in fact, my lord, in Coelho, your lordships go a step further and say that merely by inserting the words constituent power in Article 368, the Parliament has no greater power than power of amendment. It's not an original constituent power. They may have used it, and that's why, my lord, in Minerva Mills, your lordship struck down sub-articles 4 and 5. Precisely for that reason. So, power of amendment, your lordships have consistently held, is subject to constitutional limitations. Now, how do we, therefore, my lord, look at this? My lord, your lordships have always said, and this is very, my lord, interesting, as Samant puts it, my lord, the duty of judicature is to act upon true intention of the constitutional framers, the Constituent Assembly. That means sententia legis. How do you gather that intention? Can you travel outside Article 370 as what the government would like your lordships to do? In my respectful submission, no. The entire basis of the arguments are circumstances prevailing today to justify this exercise and then to persuade your lordships that this is what Article 370 means and that's why it's temporary in nature. Now, my lord, don't take anything. 300 370. Lordships have said that your lordships have liberty to, my lord, interpret the constitution within permissible limits. Your lordships have always, my lord, upheld that principle very soundly. But the government wants your lordships to read something which, my lord, I find it very difficult to understand on a plain reading and clear intention of the constitutional framers. My lord, these were men and women of extraordinary wisdom. They've worked for over 2 years to draft the constitution. But whatever their intention was, they have put it in this article. We don't need to travel outside at all to find out what that intention is. And that intention is in 371C.
Please see 371C, don't turn to it. It says, provisions of Article 1 and of this article shall apply in relation to that state. So they have permanently embedded 370 into the Constitution, along with Article 1. Having embedded that, because it is through Lord 1C that 1A, B will come into play. Because they have now said 370 shall apply in relation to Jammu and Kashmir. Now, Lord, they were aware that, Lord, they had some understanding with the state, where state wasn't sure whether it wanted to continue this association with us or not. So they, Lord, therefore drafted sub-article 3 to say, notwithstanding anything in the foregoing provisions of this article, on the recommendation of the Constituent Assembly, I am paraphrasing it, on the recommendation of the Constituent Assembly of the state, President may, by public notification, declare that this article shall cease to be operative or shall be operative only with such exceptions. Now, my lord, can any other meaning be given to the expression Constituent Assembly? Contrary to what they had said, because that's also used in sub-article 2. Today, Lord, after 70 years, you might say, read Constituent Assembly to mean Legislative Assembly, and legislature to mean Parliament. Lord, I respectfully submit that this is the limiting provision. The temporary nature of the article is in sub-article 3, because they wanted to give people of Jammu and Kashmir, through the Constituent Assembly, the right to decide whether they wanted to continue with India, whether they wanted to follow Constitution of India or not. Nothing more, nothing less. Otherwise, 370 is embedded into the Constitution. And it's not temporary, it's permanent. An exercise under sub-article 1 is therefore permanent exercise to be done from time to time. For principle of contemporaneous exposition, for 70 years, if government of India, order after order after order, exercises powers under Article 370, can it now lie in their mouth to say that Article 370 is temporary? That's how they've understood. That's how they've acted. Merely because government has changed of a new party, does it mean that it has suddenly become overnight temporary? This is something which I want your lordships to kindly appreciate, that 370 was never intended to be temporary in its heart and soul. Only temporary nature was to give the right to the Constituent Assembly to decide what do you want. If they had decided, no, we don't want it to continue, President could have issued the order. Instead, they said, no, we want to be part of India, we want Constitution to apply. But we want it to be applied in the sense of Article 371. And 2, essentially 1, consultation and concurrence. Is it not something extraordinary that is being done? It is not the case of Government of India that 370 has not worked over the last 73 years. Not one example to show that 370 has failed. Every time the Government of India wanted to apply anything, any article which was left out or any law which had to be applied, it was automatically accepted by state of Jammu and Kashmir and its assembly then and subsequently state governments. So it is very unfathomable that why is it that suddenly overnight you get up and say now. And that's not something which your lordships must appreciate. I've said in my written submissions earlier, in their manifesto, BJP categorically says in 2019, we reiterate our position since the time of Jansang to the abrogation of Article 370. This is the only material with the President of India, nothing else, with greatest respect, in all humility at my command. They wanted to have, because Lord, Jammu and Kashmir and 370 has become a bone of contention in this country between amongst some sections of society. But nobody has understood what 370 is. 370 is not integrating Kashmir into India. And your lordships say again and again in the two judgments, which I will now straight away refer to. Lord, I respectfully submit, your lordships must very carefully scrutinize Lord Kaul's case, Premnath Kaul, and Lord Sampath Kumar. Both judgments support my submission on every point. Both answer to what the government of India has said, and they both provide answers to the questions that your lordships have raised from time and again, including on sovereignty. I'll read, my lord, just 4 paragraphs from each. My lord, PDF page 10 in Premnath Kaul, it's volume 1, it starts at page 7. Just note, don't turn to it, my lord, unless your lordships have time, my lord, because we are running against time. But this is what your lordships say. PDF page 10, volume 1, page 7, it starts at 10. Clause 8 is very important. It says that nothing in the instrument affects the continuance of Maharaja's sovereignty in and over his state, or save as provided by or under instrument, the exercise of any powers, authority, and rights then enjoyed by him as the ruler of the state, or validity of any law then in force in the state. Then, my lord, your lordship say, after the act was enacted by the Yuvraj, my lord Chief Justice rightly queried, after the act was enacted by Yuvraj, he issued a proclamation on April 20, 1951, directing that Constituent Assembly consisting of representatives of people elected on the basis of adult franchise shall be constituted forthwith for the purpose of framing constitution of a state of Jammu and Kashmir. In accordance with this proclamation, Constituent Assembly was elected and it framed the constitution. Then your lordship says something very, my lord, important. But it is urged, my lord, this is PDF page 16, para 26. But it is urged that sovereignty of Maharaja was considerably affected by provisions of instrument of accession which is signed in October 25. This argument is clearly untenable. It doesn't stop here. Even subsequent proclamation onwards, your lordship say his sovereignty continues to legislate. And your lordships, when your lordships were called upon to decide whether a matter should be referred to a larger bench or not, your lordship said that there is no conflict between Premnath Kaul and Lord Sampath Prakash. Therefore, your lordships declined to refer it. And your lordship said law precedent binds us in that judgment. So, my lord, these two judgments in my respectful submissions are binding on every point that's been raised. Now, see further. It is true, my lord, it is true that by clause 1 of the instrument of accession, His Highness conceded to the authorities mentioned in the said clause the right to exercise in relation to his state such functions as may be vested in them by or under Government of India Act 1935 as in force. Now, my lord, this
No, Mr. Dwivedi, we made it clear that 4 o'clock today we are concluding. Whatever now remains, you can give us submissions and rejoinder. Because even in rejoinder, now we have heard 5 counsel. We have heard Mr. Sibal, Mr. Gopal Subramaniam, Mr. Zafar Shah, Dr. Rajiv Dhawan, and now Mr. Dave is on his legs. So I think 5 counsel in rejoinder is I think.
Lordship may
broad.
at least give 15 minutes today extra, if possible.
The fee and I had said when we were arguing, that cutting down our submissions to argument.
So what we'll do is,
No.
we will,
Instead of half an hour, you stayed reorganized. Half an hour, you were in 2 hours, so you can't say that you were to argue and rejoin us.
what we will do is, we will,
On the state reorganization, specific.
we will continue for 15 minutes. We'll wrap up at 4:15. After that, anybody wants to give us anything in writing, not more than 1 page, to just sort of highlight the bullet points.
I would need about 10 to 15 minutes. Now, I'm only on the State Reorganization Act.
With no difficulty, but all within 4:15. We have to write it. 4:15 we'll be right.
But some latitude.
And 4:15
is 4 to 4:15.
Because the half day on Monday was taken by the respondent, which your lordships had actually apportioned Monday and Tuesday to us.
But then you also took the half day the previous week, you know.
So,
9 days. 9 days
9
to
days.
precise for arguing and opening.
Anyway, no, that
1.5 days in rejoinder.
So
let's
what
not
we'll do
complain
now
about
is
time.
that, we'll exactly at 4:15, we will say that we have heard arguments, judgment is reserved. Any further submissions and rejoinder may be submitted within a period of 3 days, not exceeding 1 page for each of the
Conclude,
rejoinders.
I can. I didn't get even 10 minutes. I've been requesting all of them.
We are here till 4:15. After that, this will be the order which will be recorded.
Yes.
That
Don't interrupt,
one page of rejoinder submission.
So, Lord, this is what your lordship say in paragraph 31, PDF page 17. It's true that by clause 1 of instrument of accession, His Highness conceded to the authorities mentioned in the said clause the right to exercise in relation to his state such functions as may be vested in them by Government of India Act as in force. But this was subject to other terms of the agreement of accession. And clause 6 of the instrument clearly and expressly recorded continuance of sovereignty of His Highness in and over his state. There is no substance in this argument. They rejected the argument on behalf of the petitioner that sovereignty had come to an end. Then, my lord, your lordship further said, my lord, one paragraph.
Mr. Ravi, we'll look at call. Call has been
Yes.
read over.
No, but this is little important because this answers all questions. To my mind, my lord, respectfully, my lord, I may say so, will not be at the cost of repetition, that every one of the arguments raised by them stands covered by these 2 judgments. And they have not explained these 2 judgments in their arguments.
Paul and Sampath.
Paul and Sampath Kumar. Sampath Prakash.
Yes.
Now, please see. Lord, Article Clause 2. This clause shows, Lord, this is on Clause 3, sorry. Thus, the proviso to Clause 3 also emphasizes the importance which was attached to the final decision of the Constituent Assembly of Kashmir in regard to relevant matters covered by Article 370. This is not PDF page 17, para 31.
Yes.
Then, my lord, your lordships say at page para 40, the constitution makers were obviously anxious that the said relationship should finally be determined by Constituent Assembly of the state itself. Please see this, my lord. Paragraph 40, PDF page 20. Constitution makers were obviously anxious that said relationship should be finally determined by Constituent Assembly of the state itself. That is the main basis for and purport of the temporary provisions made by the present article. And so the effect of its provisions must be confined to the subject matter. The temporary nature, according to your lordships, my lord, in Premnath call was till Constituent Assembly, my lord, approved it. It did. President accepted that approval and issued, my lord, presidential order.
Yes.
So, my lord, this is completely, now, my lord, neither subsequent proclamation issued by Yuvraj Karan Singh adopting as far as possible proposed constitution, nor constitution order subsequently issued by President purported to impose any limitation on the legislative powers of the ruler. So, my lord, your lordships have held that the sovereignty of the ruler continued even after, my lord, the acceptance of the constitution, after Article 1 was applied, after, my lord, presidential orders were issued. My lord, in Sampat Prakash, your lordships, my lord, have gone a little further and said, my lord, this is what your lordship say. Now, my lord, in Sampat Prakash, just note this is very important. My lord, PDF, my lord, volume 1, page 4, at page 30, page 29-30. My lord, these very arguments were raised by the petitioner there. The first argument was that article contained temporary provisions which ceased to be effective after Constituent Assembly convened for the purpose of framing Constitution of Jammu and Kashmir had completed its task. Then what are the grounds they give in support of that? They say, my lord, these special circumstances to which reference was made by him were, one, there had been a war going on within limits of Jammu and Kashmir. There was a ceasefire. That conditions in state were still unusual. That part of the state was still in hands of rebels. And that country was entangled with United Nations in regard to so-and-so. Noting all these arguments, your lordships, my lord, rejected the argument that it is temporary. Lord, at para 7, at PDF page 30, your lordship says, Lord, very emphatically, there are, however, much stronger reasons for holding that provisions of this article continued in force and remained effective even after the Constituent Assembly of the state had passed the constitution of the state. Then your lordship say, in fact, no such recommendation was made by the Constituent Assembly of the state, nor was any order made by President declaring that article shall cease to be operative. On the contrary, it appears that Constituent Assembly of the state made a recommendation that article should be operative with one modification to be incorporated in explanation. This modification in article was notified by President by Order 44, laid down that from 17 November article was to be operative. This makes it very clear that the Constituent Assembly of the state did not desire that this article should cease to be operative and in fact expressed its agreement. Please allow me. This article, this makes it clear, Lord, PDF para 7. This makes it very clear that Constituent Assembly of the state did not desire that this article should cease to be operative and in fact expressed its agreement to the continued operation of this article by making a recommendation that it should be operative with this modification only. In view of these provisions, it must be held that Article 370 of the Constitution has never ceased to be operative. What are they arguing, my lord? Can government of India in the face of law declared by this court under Article 141 say that it has ceased to be operative? Or that it was temporary? Never ceased to be operative, and there can be no challenge on this ground to the validity of orders passed by President in exercise of powers conferred by this article. The argument was that presidential orders are without authority of law because Article 370 has ceased to be operative. They said no. Why? Because they said Constituent Assembly agreed that it should be operative and it was continued thereafter. So what 5 learned judges of this court in both these judgments have categorically held. Now, my lord, so far as amendment of Article 368 was concerned, as my lord applied to Jammu and Kashmir, your lordship said only one thing, that thus Article 368 is not primarily intended for amending the constitution as applicable in Jammu and Kashmir, but it is for the purpose of carrying out the amendments made in constitution for rest of India into the constitution as applied in state of Jammu and Kashmir. Lord, PDF page 33, para 13. So your lordship went to the extent of saying that those provisions of amending the constitution there is no time to read anything. So, my lord, your lordships went to the extent of saying that amendment to Article 368 insofar as J&K is concerned is not for the purpose of amending constitution. It is only for the purpose of ensuring that amendments in Constitution of India are effected in Jammu and Kashmir. Expressly, your lordships hold that. These two judgments, therefore, now, my lord, the union has relied on Damnu's case. Lord, Damnu does not, water down this position at all. Damnu, in fact, my lord, volume 1, PDF page 45 says that necessity of concurrence of the state government or consultation of state government is a must for the purpose of Articles 371A and 1B. And therefore, they said that they place no limitation on Jammu and Kashmir constitution. So Damnu was an entirely different situation. Now, my lord, as I said, Lord, in my opening arguments, what is the situation? So, my lord, suddenly the British decide to leave. There is a vacuum. By the Independence Act, Lord, they said that now there will be two dominions, Pakistan and India. The territories will be those which were part of British India, subject, of course, to the princely states agreeing to come into India or Pakistan, as the case may be. So, my lord, these accession treaties were entered into. Now, my lord, if that is so, then, my lord, as Berubari expressly holds, if a treaty has been incorporated in the constitution, 370 is a classic example of incorporation of that treaty. My lord, clause 6 of the instrument of accession is bodily lifted into 370 in spirit. Now, once it is, treaty has been constitutionally recognized, you cannot, my lord, pass any order to undo that. Lord, the whole, what was the purpose? Why were the constitutional framers so conscious of it? Because they wanted to bring about some kind of a resolution which will be permanent in nature, to solidify relationship between Jammu and Kashmir and India. It was not for the purpose of temporarily joining them. They wanted to solidify the relationship of J&K with India. And they realized that the only way we can do it is through the means of Article 370. Because any other way, we would have lost Jammu and Kashmir. So they were very conscious. Now, can we go behind what they have done or what they have expressly referred to in the article itself? So Berubari, my lord, expressly holds that if it is a treaty, and if treaty has been recognized by the constitution, then the only way you can undo it is by amending the constitution. And Berubari was a case of physical territory. Now, Reorganization Act is a classic example of physical territory of Jammu and Kashmir, which came into India by a treaty, now being subjugated or divided or dismembered into union territories. And you are relying for that purpose a legislative power of parliament to do it, without amending the constitution under Article 368. Berubari says that you can only follow constitutional amendment under 368 and the strict procedure prescribed thereunder. Nothing else, nothing more. And it defines sovereignty very beautifully. Now, my lord, therefore, my lord, these are, my lord, examples where history, your lordship knows, from 1921, there was a war which went on in Northern Ireland. In 1998, British Parliament had to concede And the Northern Ireland Legislative Assembly was not given away many powers which British Parliament was exercising. Because they wanted permanent peace. Now, it's not that people of Jammu and Kashmir will die if 370 is not taken away. It's not that. Question is that people have a right to feel that what was understood constitutionally, a constitutional promise, can it be taken away in this manner that has been done? The whole, they are also citizens of India. They are not some foreigners. You are taking away from a sizable section of citizens of India a special status which was conferred upon them by constitutional framers. Parliament, merely because Parliament has majority, does not have a right to scrap constitution. Constitutions live for eternity. And there is nothing, Lord. Even after 2019, violence has gone on unabated. Every week, Lord, we find people are being killed. Soldiers are dying. You have almost 1 million troops in Kashmir. You travel from Srinagar to Pahalgam or Gulgar, every 100 feet, an armed policeman is standing from paramilitary forces. Hundreds of vehicles fly on those roads. So, this argument that there is development and yes, tourism has developed because Kashmir is not the most beautiful place on earth. It's heaven. Anybody who has been to Switzerland will tell us, and Mr. Sibal will tell us because he has seen it much more than I have, that Kashmir is far more beautiful than what Switzerland can be. Switzerland is manicured and pedicured.
When we go for official visits, we don't see Switzerland.
So, what I am respectfully submitting, that ultimately people have a right to expect that their status, their rights are respected for longevity. It's a lifetime's promise. It's not a promise for the moment.
Yes.
So, we are seeing, as Dr. Dhawan rightly referred to Israel, what are we seeing today? For 56 weeks, today, 56 weeks, the constitutional amendments taking away powers of the Supreme Court are being resisted by thousands and thousands of people from across the society, civil society, business community, labor unions, lawyers, soldiers, serving soldiers. Everybody is up in arms. Why? Because Constitution is so dear to us. It must remain in our heart. If constitutional morality is allowed to be tempered with, trifled with in this fashion, then nothing, Mr. Courtmaster. Mr. Courtmaster. Constitutional morality, as Grote says and Dr. Ambedkar quotes him, constitutional morality must be in the heart and bosom of every citizen. Let us not allow union to steamroll so that people lose their love and affection. Now, there is one aspect on federalism that I want to cite from Dr. Ambedkar's debate, which is very important. In his closing remarks, this is what Dr. Ambedkar said brilliantly.
That was read out yesterday. Actually.
No, this part perhaps was missed out. I was hearing it.
Yes.
There is only one point of constitutional import to which I propose to make a reference. A serious complaint is made on the ground that there is too much of centralization and that the states have been reduced to municipalities.
It was read.
Yes. Now, this aspect is very important because he calls basic principle of federalism is that legislative and executive authority is partitioned between center and states, not by law. Yes. Now, if Constitution has conferred this special status, then I respectfully submit.
This is volume 8, page 5 and volume 8, page 1299. Mr. Giri, you read out this extensive.
Now, Mr. Giri read also the aspect of whether democracy will be lost. Dr. Ambedkar says further, which he certainly didn't read. Democratic system India lost. Will she lose it a second time? I do not know. But it's quite possible in a country like India that democracy. This was not read. I was sitting. From its long disuse, must be regarded as something quite new. There is danger of democracy giving place to dictatorship. It's quite possible for this newborn democracy to retain its form, but give place to dictatorship. In fact, if there is a landslide, the danger of second possibility becoming actuality is much greater. Happened in 75. It happened in 1975. We cannot, Lord, these are not, Dr. Ambedkar's every word, Lord, in the opening and the closing speech is not, it must be written in golden letters by us. It should be in our heart. We cannot not overlook the fact that not ultimately, not as Burke says and Ambedkar quotes him, that you can't rule by force all the time. And if you have to rule by force, then there is no governance at all. So I respectfully submit that your lordships may not kindly accept the interpretation that Lord, we are canvassing, that 370 is permanent in nature and that sub-article 3 was temporary in nature. That power was exercised, it was exhausted. And Lord, in place of Constituent Assembly, it's a fraud on Constitution, Lord. To say that now, Lord, Legislative Assembly, Governor, President, Parliament, everybody can exercise powers in respect thereof. How do you, Lord, ascribe, it's doing violence to the plain language of the constitutional framers. And that, in my respectful submission, Lord, your Lordship's court have never permitted. Ultimately, it's your Lordship's court which has always upheld rule of law. So, Lord, I respectfully submit that these petitions deserve to be allowed and the orders deserve to be submitted.
All other submissions may be filed not more than 1 page, at the most 2 pages.
Man, only one request.
Just one thing, one second. Look, I was, your lordships had told me to curtail my argument because your lordship said I want to call on them with regard to the state reorganization. I need to put in a substantial rejoinder. 150-page written submissions are put in and arguments are made, Lord, which are completely contrary to the facts. Your lordships were told by the solicitor that Mr. Singh has kept from you the Jammu and Kashmir Reorganization Act. Had he shown your lordship the act, you would have seen that nothing has changed. Everything is there. I need to put in so I will put in, please don't hold me down to 1 page. I appreciate that your lordships don't want to sit tomorrow. But I must at least some latitude, about 4 or 5 pages in rejoinder. I'll put in a brief note. I will not repeat anything, but I will deal with it. Otherwise, this whole aspect that I will only want to address your lordship.
Do that in 2 pages, Mr. Singh, because now we have heard arguments. We can confine it to 2 pages. The bullet points you can pull at.
Deal with the submission. The solicitor solemnly tells your lordship certain things which are contrary to the fact, but he told your lordship that the act, and he handed up copies of the act. He said, had you been shown the act, Mr. Singh has made a big deal about Article 246, this, that, but nothing has changed. Everything is given to
that will lead to multiple responses from this side and that side. Go on.
You're not sitting is
therefore, Mr. Singh, now 2 pages you can certainly give us. 2 pages. I think there's, you imagine if we give you 5 pages, there will be at least 10 to 12 council who would want to file. We'll have another 60 pages to, and then they will say we will file submission for another 60 pages. So that.
Your lordships have.
So what we'll do is,
July we were frozen, we stuck to it.
Mr. Sibal was.
Stick to it. They filed 250 pages worth of submissions are filed by one person.
But volume is not always equivalent to something that you have to read every
Question of fact
or respond to everything. There sometimes there are charts, there are other things, and
I'm only on the state reorganization. I mean, some latitude.
Manoj, on behalf of Mr. Nafe also. Manoj, on behalf of Mr. Nafe also.
Mr. Sibal was to share the affidavit, Manoj. No, we would like to see, Manoj. We have not received the copy.
Manoj, I had on behalf of Mr. Nafe also, Article 368 argument for amendment.
Everybody has argued the same thing with respect again and again.
368, Manoj. Not the amendment.
The affidavit.
Manoj, there's a different view on amendment to 368, so just 2 pages. Just within 2 pages for my submission.
Only a minute, Mr. Lord, it says I am a responsible and dutiful citizen. I have exercised my right to approach this court. I reiterate the oath taken while being sworn in as a member of parliament.
Preserve and uphold the provisions of the Constitution of India and to protect the territorial integrity of India.
But this is not rebuttal, my lord. This is adding insult to injury to the nation.
We'll analyze what is there in the.
Kindly, my lord, say something about it. I leave it at that.
Say what?
The lordships have
3 pages. One of the requests for
Well,
3.
we must end it with a vote
That's
of thanks
correct,
to all the
Your
members of the
lordships
bar.
may-
Thank you very
Your
much.
lordships may read what is not written. Your lordships may read what is not written.
Saying something.
Thank you, Lord.
Thank you very much.
And thanks to Nodal Council also. Nodal Council, they have done a great job.